Good afternoon, ladies and gentlemen. The afternoon section shall commence soon, so please be seated. A gentle reminder, please kindly switch your mobile phones or any electronic devices to silent mode. Once again, the Congress will be conducted in English and Cantonese with separate channels for simultaneous interpretation in Cantonese, Putonghua, and English. Please tune to Channel 1 for English, Channel 2 for Cantonese, and Channel 3 for Putonghua. You may pick up your headsets, SI headsets, at the entrance of this room. If you wish to have a SI headset, please raise your hand and our event team will pass one to you. For online participants, you may choose your preferred language as shown on the screen by clicking the channel directly. You're recommended to use headphones for better sound experience. Ladies and gentlemen, our afternoon section will commence now, so please be seated. Thank you. Ladies and gentlemen, good afternoon. Welcome back to the afternoon section of the Rule of Law Congress, Rule of Law and Justice for All. On stage, we're now having our second panel section of today, titled Access to Justice for All, Diversified Dispute Resolution Mechanism. And we're so delighted to have the following moderator and speakers moderating the section. First, let me introduce our moderator, Mr. Victor Doss. A big round of applause to welcome Mr. Doss. Mr. Doss is the chairman of the Hong Kong Bar Association. And joining us on stage, we have three distinguished speakers. They are the Honorable Mr. Justice Tang, Mr. Rimsky-Yuen, and also Ms. Winnie Tam. Welcome our speakers. Before I pass the stage and time to our moderator, Mr. Doss, just a gentle reminder to all of you, if you have any questions for our speakers and moderator, remember to pass your question to our moderator and our team by filling the question paper provided to you earlier. Or you can simply scan the QR code that is now shown on screen and type your questions into our Q&A system directly. For online participants, you can simply type your questions in the chat box at the bottom of the screen. Without further ado, our speakers are now ready, so I would like to pass the time and stage to our moderator. Mr. Doss, over to you.
I want to welcome everyone to the second panel session of today. The title is Access to Justice for All, Diversified Dispute Resolution Mechanism. And I'm thrilled to be joined by a very distinguished panel. I'm sure most of you are actually familiar with our speakers today, and you'll forgive me for keeping the introduction to relatively short. In the order of presentation, can I first of all introduce Mr. Rimsky-Yuen, SC. As most of you know, he's the chair of the Hong Kong Mediation and Accreditation Association. He is also the co-chairperson of the HKIAC, a practicing senior counsel, arbitrator, and mediator. And a lot of you will remember Rimsky as our former Secretary for Justice from 2012 to 2018. The second speaker is Mr. Justice Robert Tang, currently a non-permanent judge of our Court of Final Appeal and one of the most popular arbitrators in our jurisdiction. A lot of you in this room, in fact, looking around, I think most of you are practicing lawyers in this jurisdiction, and I'm sure most of you would have read and have cited Robert's judgment in your practice. Robert was a member of the Hong Kong Bar since 1970. He was appointed Queen's Counsel in 1986. He joined the bench in 2004 as a judge of the Court of First Instance and was promoted to the Court of Appeal in the following year. He joined the Court of Final Appeal in 2012 and retired as a full-time judge in 2018. Now, last but not least, of course, we have the rows between the phones. Ms. Winnie Tam, SC, Winnie is also a practicing senior counsel, and in addition to being our top intellectual property specialist, Winnie is a recorder of the High Court. She sits as an arbitrator in a wide range of commercial cases. And then on top of all that and outside the law, Winnie is also the chairperson of the Hong Kong Palace Museum Board, and she also chairs the Communication Authority. We can all ask her later where does she find time for all that. Finally, it gives me great pleasure also in that all three of them were my predecessor, and they were all chairmen of the Hong Kong Bar Association. They left very big shoes for myself to fill. Returning to the topic today, access to justice. Provision of affordable and effective and timely legal and dispute resolution service is certainly an important component when we consider the rule of law. As an international dispute resolution hub and an IFC, Hong Kong has really got a diverse dispute resolution mechanism catering for the needs of our citizens and also our friends from abroad. In fact, I was inspired by Professor Tirado when we spoke about food in Hong Kong the other night when we were at the Legal Week races. But I was just reminded by Secretary for Justice that he actually used the same analogy this morning. So at the risk of being accused of plagiarism, I will stick to my point. What we talked about was how he loved eating in Hong Kong, and that there's really something for everyone, from Michelin star cuisine to the authentic hawker stores you can find around town offering cheap and tasty food. There's really something for everyone. And like the Secretary of Justice, I do think we can say the same thing about dispute resolution services here. No matter whether you have a high-value arbitration or litigation, or just a small dispute between neighbors, you'll be able to find something that would ensure that your dispute is resolved in an economic and proportionate manner. So on that note, and without further ado, I will first invite Rimsky, who will give us an overview on the different options in Hong Kong. Thank you very much, Rimsky.
Secretary of Justice, distinguished guests, ladies and gentlemen, good afternoon. First of all, may I express my gratitude to the Department of Justice for giving me this opportunity to share with you some of my personal thoughts on the topic chosen for this session, namely, access to justice for all, diversified dispute resolution mechanism. As the first panelist, I intend to give you a snapshot of the situation in Hong Kong. The other two panelists, Robert and Winnie, will focus on individual areas relevant to the topic in question. It has been generally accepted that the rule of law in Hong Kong is a cornerstone of Hong Kong's success, especially in respect of her role as an international city and in particular as an international financial center. Today, of course, is not the occasion to embark upon a detailed jurisprudential discussions of the concept of the rule of law. However, for present purposes, one point is sure. Access to justice and dispute resolution are two of the important and interrelated elements of the overall concept of the rule of law. Put shortly, even the best legal and judicial system would become meaningless if legal disputes cannot be resolved fairly and effectively, or that parties who believe their legal rights have been infringed cannot have access to an effective dispute resolution regime in one way or another to satisfactorily enforce their legal rights. In the well-known text of the rule of law by Lord Bingham, the learned judge explained this concept as follows, and if I may quote, "It would seem to be an obvious implication of the principle that everyone is bound by and entitled to the protection of the law, that people should be able, in the last resort, to go to court to have their civil rights and claims determined. An unenforceable right or claim is a thing of little value to anyone. End of quote. In Hong Kong, the right to access to justice is constitutionally guaranteed under Article 35 of our Basic Law, which reads as follows. Hong Kong residents shall have the right to confidential legal advice, access to the court, choice of lawyers for timely protection of their lawful rights and interests, or for representation in the courts and to judicial remedies. Hong Kong residents shall have the right to institute legal proceedings in the courts against the acts of the executive authorities and their personnel. Article 39 of our Basic Law also provides, among others, that the provisions of the International Covenant on Civil and Political Rights as applied to Hong Kong shall remain in force and shall be implemented through the laws of Hong Kong. In this regard, Articles 10 and 11 of the Hong Kong Bills of Rights, which deal with equality before courts and right to fair and public hearing, as well as right of persons charged with or convicted of criminal offense respectively, which are set out in Part 2 of the Hong Kong Bills of Rights Ordinance, are also important provisions in the context of access to justice. In addition, access to justice is protected under common law. Indeed, the common law right of access to court has often been described as a constitutional right. Among others, such right is reflected in the well-established common law presumption of legislative intent that access to the court in respect of justiciable issues is not to be denied save by clear language. Besides, the ability of an individual to bring prosecution is another facet of this right of access to court. Nevertheless, access to justice is not and should not be confined to access to courts, which resolve civil disputes through conventional court litigation. An effective dispute resolution system, other than that of the court, is equally important. Indeed, as early as April 1976, Professor Frank Zender of Harvard Law School started to articulate the concept of multi-door courthouse in a conference concerning the administration of justice. Looking at matters as they now stand, I would venture to suggest that Hong Kong's dispute resolution landscape offers a modified and enhanced version of Professor Zender's idea of multi-door courthouse. The key reasons, if I may venture to suggest, include, first of all, the judicial system of Hong Kong is there to act as the ultimate gatekeeper of dispute resolution, and thus also the ultimate gatekeeper of justice. Second, in addition to court litigation, there are various other means of dispute resolution available for the parties to choose. Key examples include arbitration, mediation, and adjudication. Third, the question of cause is one of the key considerations in dispute resolution. The system of legal aid in Hong Kong and also the recent development concerning the funding of arbitration and mediation in Hong Kong are effective means to uphold the concept of equality before the law as well as to ensure access to justice. For present purposes, I would briefly deal with these three aspects. Starting, if I may, with the court system. Article 19 of our Basic Law stipulates that the Hong Kong SAR shall be vested with independent judicial power, including that of final adjudication. It goes on to provide that the courts of the Hong Kong SAR shall have jurisdiction over all cases in the region, except that the restrictions on their jurisdictions imposed by the legal system, and principles previously enforced in Hong Kong shall be maintained. Section 4 of the Basic Law specifically deals with the judiciary. A few of the provisions contained in Section 4 merit attention. Article 80 stipulates that the courts of the Hong Kong SAR at all levels shall be the judiciary of the region, exercising the judicial power of the region. Closely related to this is Article 85, which provides that the courts of the Hong Kong SAR shall exercise judicial power independently, free from any interference. Another provision of importance in the Basic Law is Article 82, which stipulates that power of final adjudication shall be vested in the Court of Final Appeal, which may, as required, invite judges from other common law jurisdictions to sit on the Court of Final Appeal. In recent years, the arrangement under Article 82 concerning overseas non-permanent judges of the Court of Final Appeal has attracted certain discussions. Some discussions go beyond the Court of Final Appeal and touches on nationality of our judges. Since Article 90 of the Basic Law only imposes nationality restrictions on the Chief Justice of the Court of Final Appeal and the Chief Judge of the High Court. Healthy discussions on topics of public importance is a reflection of, and indeed, the aim of any democratic and open society. Constructive discussions can bring about desirable changes which can make our society a progressive one. However, in discussing matters concerning the judiciary, especially those that are governed by the solemn provisions of the Basic Law, one should perhaps bear in mind that those relevant provisions in the Basic Law represent the result of serious and lengthy discussions during the drafting of the Basic Law. They were included in the Basic Law for good reasons. In particular, the participation of overseas judges in our Court of Final Appeal has been viewed positively by the international business community. It also helps to ensure the continuous presence of international expertise of the highest caliber, as well as the facilitation of cross-fertilization in the development of Hong Kong's common law. One international trend that may be worth mentioning in this regard is the growing popularity of international commercial courts in different jurisdictions. In some of these international commercial courts, such as the one in Singapore, a similar formula is adopted in that foreign judges are invited to sit in their international commercial court. With the constitutional safeguard and the professionalism of our judges, court litigation continues to be an effective means of access to justice in Hong Kong. Moving on, if I may, to other forms of dispute resolution. Arbitration is, of course, one of the most natural options that springs to one's mind. Unlike court litigation, the mandate of the arbitral tribunal is derived from the parties' arbitration agreement. The concept of party autonomy is one of the key pillars of arbitration. Freedom of choice over arbitrators and also procedure, confidentiality, and ease of enforcement of arbitral awards pursuant to the New York Convention are the key factors which explain the popularity of international arbitration. They are also the reasons why international arbitration provides a robust alternative to court litigation in terms of access to justice. The development and promotion of arbitration in Hong Kong has a long history. Since the setting up of the Hong Kong International Arbitration Center in the 1980s, arbitration whether domestic or especially international, has gathered momentum in Hong Kong. Arbitration is not conducted in a vacuum. Supporting legislation is of paramount importance. That's why the Department of Justice continuously keeps a close eye on the development in the arbitration landscape and has introduced significant changes to the arbitration ordinance in the past 2 decades so as to ensure that the arbitration legislation in Hong Kong can meet the needs of our end users. Further, there is the support of the arbitration-friendly judiciary. Against such background, coupled with the hard work of the arbitration community in Hong Kong, arbitration has provided an effective means of access to justice, especially in the commercial context, which is another pillar which supports Hong Kong's status as an international financial center. Let me move on to mediation. In the 2014 mediation conference held by the Department of Justice, our then Chief Justice, that is the Honorable Chief Justice Geoffrey Ma, described mediation as follows. He said this: "I have had debates with fellow judges over whether mediation, like arbitration, can be said to be a part of the administration of justice. This is largely a sterile debate over whether the term the administration of justice is confined to what the courts do and the role of judges. For me, the administration of justice includes, as an integral activity, the resolution of disputes to arrive at a just, proper, and legally justifiable result. Mediation fits into this rubric." End of quote. Indeed, with the introduction of the mediation ordinance in Hong Kong and the subsequent apology legislation, together with the support of various mediation organizations and the dispute resolution community, the mediation landscape in Hong Kong has undergone fundamental changes in the past decade or so. In short, mediation is now another additional means of access to justice. Despite the absence of a top-down adjudication or ruling, the outcome of mediation in the form of an amicable settlement is often more receptive to the parties, as mediation can often achieve objectives that court litigation cannot. In the context of access to justice, another pertinent example perhaps is the security of payment in the construction context. The security of payment rules came into effect on the 23rd of February 2022. Cash flow has been described as the lifeblood of construction industry. The security of payment rules seeks to avoid blockage of payment or delay of payment as a result of disputes, which are not uncommon in the construction industry. The Hong Kong International Arbitration Center has since established the panel of adjudicators for the security of payment scheme and also a new set of rules so as to assist the implementation of these schemes. On the whole, there are different means of dispute resolution other than the conventional court litigation. These different means have their respective attractions. There is no one-size-fits-all solution in the context of dispute resolution. Just like our moderator Victor has mentioned, what is important is that the parties have the choice in front of them when they face disputes, just like when they face choice of restaurants, and can pick the option most suitable to the disputes they face after obtaining appropriate advices. That should be one of the ultimate aims of access to justice. Lastly, I wish to say a few words about funding of dispute resolution. Resolving legal dispute is often expensive. In the past, the court of a certain jurisdiction has been compared with the Ritz Hotel, with the connotation that unless you are rich, don't come in. In Hong Kong, various types of court litigation, such as matrimonial disputes, personal injury and fatal accidents litigation, are funded by legal aid. Compared with many other common law jurisdictions, the legal aid regime in Hong Kong is one of the most comprehensive regimes in the world. Besides, legal aid is not confined to court litigation. In appropriate cases, mediation is also covered. The funding of arbitration in Hong Kong has also undergone considerable changes. With the passing of the Arbitration and Mediation Legislation (Third-Party Funding) Amendment Ordinance 2017, and also the recent Arbitration and Legal Practitioner Legislation Outcome-Related Fee Structures for Arbitration Amendment Ordinance 2022, end users of arbitration and mediation can expect more flexibility in reaching a fee agreement with their legal teams. With such flexibility, access to justice is accordingly enhanced as well. To conclude, the choice of different means of dispute resolution coupled with the funding assistance or facilitation in one form or another are essential to maintain and consolidate access to justice. In Hong Kong, under the one country, two system, our legal and judiciary systems remain robust, and our dispute resolution landscape covering arbitration, mediation, and others continue to flourish. It remains for me to thank the organizer again for this opportunity and to wish all of you an enjoyable day. Thank you.
I want to thank Rimsky for the excellent overview on the different type of dispute resolution mechanism. Not only has he reminded us of the important constitutional safeguards under the Basic Law, covering topical issues such as our non-permanent judges in the Court of Final Appeal, he also gave us an overview of the hot topics, if I can use that term, insofar as mediation and arbitrations are concerned. So thank you very much, Rimsky. Without further ado, can I now hear from our next speaker, Mr. Justice Robert Tang, who will tell us a bit about how Hong Kong as a cosmopolitan, the role that we can play in the process. Thank you, Robert.
Secretary for Justice, distinguished guests, ladies and gentlemen. In President Xi Jinping's speech on the 25th anniversary of the establishment of the Hong Kong SAR, he called Hong Kong a cosmopolis. He said, as a cosmopolis, Hong Kong's vitality has impressed the world. In the original Chinese, he said, 香港作為國際大都會，勃勃生機，世界為之讚嘆. His description of Hong Kong as a cosmopolis is significant. According to the Collins English Dictionary, a cosmopolis is an internationally important city inhabited by many different peoples, reflecting a great variety of cultures, attitudes, etc. I believe this accurately describes Hong Kong and explains much of Hong Kong's success. Importantly, implicit in the description is the acceptance of and respect for different cultures, attitudes, etc., without which no city could truly be a cosmopolis. Elsewhere in his speech, President Xi talk about Hong Kong's status as an international financial, shipping, and trading center. And he said, quote, "The central government fully supports Hong Kong in its effort to maintain its distinctive status and edges, to improve its presence as an international financial, shipping, and trading center, to keep its business environment free, open, and regulated, and to maintain the common law so as to expand and facilitate its exchanges with the world," unquote. The rule of law is the foundation of Hong Kong. The policy of one country, two systems not only entrenched the rule of law, it was designed with Hong Kong as a cosmopolis in mind, as the following provisions in the Basic Law amply demonstrate. First, Article 24, paragraphs 4 and 5, which provide that, quote, "Persons not of Chinese nationality who have entered Hong Kong with valid travel documents have ordinarily resided in Hong Kong for a continuous period of not less than 7 years and have taken Hong Kong as their place of permanent residence before and after the establishment of the HKSAR," unquote, "and their children under the age of 18 or under the age of 21 also have the right of abode in Hong Kong." So long-term non-Chinese nationals who have taken Hong Kong as their home may become a Hong Kong resident with equal rights. Apart from a few positions, for example, that of the Chief Executive, the Chief Justice, the President of the Legislative Council, non-Chinese nationals can occupy important public positions. Few places in the world treat non-nationals so generously. Of course, unless non-nationals can feel at home here, they are unlikely to want to make Hong Kong their home. To make them feel at home and make Hong Kong their home, their different cultures, attitudes, etc., must be accepted and respected. I think Hong Kong has succeeded in that. We have a large number of non-Chinese nationals in Hong Kong who have made their homes here. According to statistics available to me, there are about 85,000 US nationals in Hong Kong as of 2018, and over 33,000 UK nationals in Hong Kong, of whom 19,000 odd are of European ethnicity, almost 7,000 Chinese, etc. As of 2014, approximately 300,000 Canadian citizens of all ethnic backgrounds live in Hong Kong. Many of these, I believe, were Hong Kong residents who had emigrated to Canada prior to 1997. The French consulate estimated that there are about 25,000 French citizens in Hong Kong. I do not have the figures, but the number of Hong Kong SAR's residents who have been educated outside of Hong Kong must be very large. There are also mainland residents in Hong Kong, many of whom have been educated overseas. Many of these people are in Hong Kong working for important local, mainland, or international businesses, without which Hong Kong would not be an international, commercial, financial, and trading center. These people also reflect the great variety of cultures and attitudes, etc., which are characteristic of a truly international city. It is this international mix which has given Hong Kong its strength. Secondly, Article 9 provides, in addition to the Chinese language, English may be used as an official language by the executive authorities, legislature, and judiciary of the Hong Kong SAR. Because of Article 9, all legislations in Hong Kong are enacted in both Chinese and English, and both versions are equally authentic. English has remained the dominant language in commerce, finance, and the law after 1997. Thirdly, Article 8, under which common law continues to be used in Hong Kong. These provisions are essential to Hong Kong's success. So too is an internationally accepted mechanism for dispute resolution. In any dispute, parties want an impartial, fair, and expert tribunal whose awards will be enforced expeditiously, fairly, and impartially. For this purpose, one needs experienced arbitrators and a strong legal profession. The importance of international arbitration to Hong Kong is obvious. That is why, as early as 1985, the Hong Kong International Arbitration Center, HKIAC, was established. I've been associated with it from its inception, and I hope I'll be forgiven if I do not mention the other arbitral bodies in Hong Kong. It was recognized from the beginning that although the Hong Kong government would provide HKIAC with the necessary seed money and its premises at a nominal rent, HKIAC would be totally independent. HKIAC has always been independent of government control. It is also truly international. It is there not to serve Hong Kong only or any sectorial interest. From its inception, HKIAC has been international with an international secretariat. Today, members of the secretariat come from different jurisdictions and speak, I'm told, 10 different languages. They are recruited on merit, regardless of their nationality. HKIAC's affairs are under the oversight of its council. There are currently 27 council members who come from 15 different countries or geographic areas. They hold passports of the United States, Hong Kong SAR, mainland China, the United Kingdom, France, Sweden, Germany, Singapore, New Zealand, Israel, Colombia, Australia, India, Korea, and Russia. It is truly international in its makeup. The current co-chairs are an ethnic Chinese HKSAR resident, Mr. Rimsky-Yuen, and a non-ethnic Chinese US citizen. There are also over 550 persons on HKIAC's panel of arbitrators, and over 360 in its list of arbitrators. They hold different passports and are admitted to practice in a variety of jurisdictions, and they practice in many different geographical areas. In arbitrations administered by HKIAC, parties are most often represented by local and international firms. However, it is important to note that subject to the parties' agreement, the practice of arbitration, whether as arbitrator or as representative or advocate, is not confined to lawyers and does not require any formal qualification. Be that as it may, an international arbitration center requires a world-class, experienced, and independent legal profession. The Hong Kong SAR is well placed to handle international arbitration. There are over 12,000 solicitors in active practice or working in-house. They are made up of different nationalities. There are over 900 local law firms and over 80 foreign law firms in Hong Kong. Do not be misled by the word local. These local firms include many leading international firms from different common law countries, most noticeably from England and the United States. The foreign law firms, and there are about 1,400 registered foreign lawyers, are firms of foreign lawyers who offer services to the public as a practitioner of foreign law, and they include lawyers from many different jurisdictions. Hong Kong has also a very strong bar. There are over 1,600 barristers and over 100 senior barristers, senior counsel. The indigenous legal profession is independent and strong. They're well-trained and have honed their skill thanks to fierce international competition. Hong Kong is, together with London and Singapore, one of the most successful arbitration centers in the world. It is no coincidence that they have in common the common law system and English as the language of their law, as well as a world-class legal profession. But is Hong Kong slipping? I do not think we need to worry, provided Hong Kong can remain a cosmopolis. Indeed, there are signs that Hong Kong is recovering. For example, the figures up to October 2022 from the HKIC shows that the number of international arbitration in 2022 has far exceeded the figures for the same period in previous years. The Chief Executive has, in his policy speech, outlined measures designed to attract talent to Hong Kong. Hong Kong is indeed open for business. But these talents will want more than a good pay package. Hong Kong has to accept and respect the great variety of cultures and attitudes, etc., not only of the talents whom we wish to attract, but also to retain the many who are already here. If Hong Kong can remain a cosmopolis, I am confident that Hong Kong will continue to be a leading international arbitration center. Thank you.
Thank you very much, Robert. I'm sure the audience would like to join me in thanking you for reminding us the international nature of this jurisdiction. Of course, the place is only as good as its people. And looking at this crowd and looking at the guests that who joined us for lunch today, I think the international nature of the city has been demonstrated vividly. So thank you again, Robert. Now, last but not least, of course, Winnie will tell us a bit more about recent issues or topics in international arbitration and share with us some of her experience in sitting as an arbitrator and as advocate in arbitration.
Secretary for Justice, distinguished guests, fellow panelists, ladies and gentlemen, thank you very much for the Department of Justice for giving me this opportunity to join the Legal Week again and to share some of my thoughts. My talk today, I've actually prepared a few slides, but the slides are not terribly important. It is just intended to give a kind of outline. I have several points to make, and they are divided into three areas. First, the first point is perhaps already covered by other panelists. It is about the rise in popularity of arbitration for commercial disputes. The second point I would like to highlight is posed in the form of a question, and that is, does commercial arbitration promote access to justice, which is the theme, diversity, in this afternoon's panel. The third point I would like to cover is how do we prepare for a better future? Diversity and inclusion in arbitration. And in that, I would like to cover 3 points, and that is diversity in the mode of dispute resolution. Secondly, diversity in arbitral panels, and diversity in fee structure, which is again a point which other panelists have touched on. The rise in popularity of international commercial arbitration is evidenced by rising numbers in every set of statistics that are published. Now, it is quite remarkable that in the past years, we have been following this Queen Mary College and White and Case international survey on arbitration. And of the 2021 figures that we have seen, 90% of respondents to the survey prefer arbitration to litigation, either as a standalone dispute resolution procedure or in conjunction with other alternative dispute resolution methods. And these other methods would include mediation and adjudication, as Rimsky has already averted to. This would be the highest proportion ever reached, I would say, and it would still be on the rise, I predict. And most remarkably, out of the top 3 most preferred centers of arbitration, 2 are in Asia. As I see it, it reflects the rise of Asia as economic forces in the world, and it also reflects the rise of Asian cities in terms of their companies being involved in international commercial activities, transactions, and hence disputes. Now, what does arbitration have to offer that is so attractive in commercial dispute resolution that 90% of people think that they would prefer international arbitration? Well, some of my fellow panelists have mentioned party autonomy. Party autonomy is, of course, the most attractive aspect because the parties who want their disputes resolved where they have a prior existing commercial relationship would like some control over the process. And often litigants in court proceedings do not find that they have a lot of control. Number one is that the judge's diary is not in your control. Recently, I've had a lengthy trial which was scheduled only to happen in the next month, and that is December, vacated altogether because the judge has been given other duties. That is unsatisfactory. I'm not blaming the judiciary for it because sometimes judges do get appointed to other roles which are important and which the rest of Hong Kong may have to pay a little price for. But that is what I refer to as a lack of control and hence increasing the lack of certainty in litigation. The next is to some degree of control over how many and who to appoint as the arbitral panel, and that is equivalent to the judge sitting as the adjudicator of the dispute. Now, of course, in a three-person panel, the party gets to choose his side of a designation of an arbitrator, and then the opponent gets to choose his designation of an arbitrator. And then the chair of the panel would sometimes be either chosen by the institution, the arbitral institution, or by the 2 designated co-arbitrators. In the case of a one-person panel, the arbitrator would be chosen by the institution very often, unless the disputing parties are able to agree. Now that, nevertheless, still offers some degree of control over how you would like the arbitral tribunal to be constituted, because the parties who are in the commercial transaction can very well agree in advance as to whether they want a 3-person panel or a sole arbitrator, or even in some commercial contracts I have seen, they've even agreed who to appoint in case they go into a dispute. Now this mode of the parties having put their minds to what will happen and what they want to happen, where before any dispute arises, is actually conducive to a smoother and easier resolution of disputes, hopefully, some of the times. Whereas parties in litigation are often engaged in more acrimonious exchanges and are more adversarial in nature. Next is the flexibility in procedure. That is often cited as another extremely attractive feature in arbitration. Whereas in court procedures, you have perhaps different chapters in the White Book, which we're familiar with, that would apply to different types of litigation. In arbitral procedures, the parties are able to put their heads together and decide right when they get into the arbitration what sort of procedure they would like to adopt, bearing in mind the actual dispute that has arisen by then. And they work together, hopefully, together with the arbitrator or the arbitrating panel in arriving at the most suitable set of procedures to follow mutually. And that, again, is conducive to a sense of cooperation between the disputing parties. In technology cases, the flexibility in procedure has played a very strong role in ensuring that the dispute is resolved and adjudicated on efficiently with the involvement of experts and the exchanging of reports and experts putting their heads together in coming up with an area of agreement, identifying only a minor or limited areas of dispute for more efficient adjudication. Next is the finality element, of course, because if the parties agree to finally resolve their dispute through arbitration, the grounds upon which they could hope to reverse the outcome of the arbitration would be very, very limited. And that ensures that the outcome of the arbitration procedure is final, rather than the parties having to wait for a number of layers of court's rulings before they would finally know whether they have won the case or lost their case. Enforceability has been touched on, and that is often cited as a very attractive feature of international commercial arbitration, because then you can choose to enforce the award in any jurisdiction. Now, Hong Kong has an advantage because enforceability of our awards in China or our judgments in China has always been provided for in legislation, but that cannot be said of a lot of other jurisdictions. Next, I would like to examine whether commercial arbitration promote access to justice. Now, some who are not familiar with arbitration would ask, why do we choose to pay for a tribunal out of our own pockets if there is a justice system, i.e. the judiciary, where you can get your dispute resolved by a judge who does not expect you to pay him? Now, that is, in fact, a question to be considered together with all the other features that support international arbitration as a preferred mode of dispute resolution. Although you don't pay for the judge, you nevertheless pay for teams of lawyers, and you risk appellate procedures, which could take much longer than you wish. And the cost of court proceedings are often not fully recoverable, even though a party may have won the battle from beginning to end. There is next the question of the struggle for equality of arms. In international arbitration, as Robert has already averted to, there is a much wider pool of talent because the legal team that participate in the commercial arbitration process does not need to be qualified lawyers or does not need to be lawyers qualified in a particular jurisdiction or in the Hong Kong jurisdiction. You have a much wider pool of talents who you can refer to and seek help from to conduct the arbitration on your behalf. Not even the tribunal, members of the tribunal are required to be of qualifications held in a particular jurisdiction. And sometimes that is necessary because international parties who are engaged in disputes may be parties who have nothing to do with Hong Kong, or maybe one of the parties could be a Chinese corporation. For example, recently I have an arbitration involving Russian parties and Chinese corporations, and the language that was adopted in the arbitration was English. And then we have a panel of arbitrators of diverse qualifications and origins. The lawyers who were handling the cases were Chinese lawyers with Russian lawyers backing up. So we have this diverse pool of talents that the parties can rely on in international arbitration. Whereas in court proceedings, the team of solicitors having conduct of the matter will always have to be lawyers qualified in the particular jurisdiction, and the advocates representing the parties will always have to be properly qualified in the Hong Kong jurisdiction, for example, and the same in any other jurisdiction, indeed, except for advocates who are admitted on an ad hoc basis, on a case-by-case basis, to that particular jurisdiction. There is a myth of cliques of arbitrators. It is concerned, it has been sort of rumored to be a concern amongst the litigation professionals that, in international arbitration, there would be suspicions of unfairness because international firms tend to get the big cases, and then they would be friendly with the arbitrators they appoint or did not appoint, or even the chair who they did not directly appoint, and arbitrators would want to please these big firms in order to get repeat appointments. Speaking as an arbitrator who has regularly sat in cases for the past 7, 8 years, I do not find that to have any truth in it. Although I have seen arbitrators who tend to be sort of ostensibly polite or sort of more obliging to particular firms. That could be for other reasons. That could be because that particular firm has already a good understanding of the culture in arbitration and understands the limits of behavior or adoption of practices. For example, in a particular type of application, they wouldn't make submissions which are off the line and therefore are received with more favor from the tribunal. So it does not necessarily mean that the tribunal would necessarily find in their favor just because a particular firm or a particular advocate is more reputable or famous or has more cases, as the case may be. There is this particular element that we should bear in mind, and that is, it is important for an international arbitrator to retain respect amongst his peers or her peers. And that element is a driving force to behave properly and to demonstrate fairness at all times. Next, what choices are offered, also on the point of what choices are offered in commercial arbitration that litigation does not offer? Well, we have consensual dispute resolution in international arbitrations. So parties have agreed in advance to resolve disputes in a particular manner, say arbitrations in Hong Kong IAC under Hong Kong IAC rules. And they can also agree to the formats and the procedure that will be tailor-made to suit their needs of the particular dispute or the particular type of contract. The consensual nature of arbitration means that parties to commercial contracts will have put their minds to the nature of their agreements and how disputes are likely to arise. And parties, well, you can say that, well, but one party may have a stronger bargaining power. And for example, I hear that American companies in recent years, they do not necessarily want their disputes with any Chinese entities to be resolved in Hong Kong because they have suspicions or pretexts that Hong Kong may not be an independent jurisdiction anymore. Of course, there's absolutely no truth in that. And there is absolutely no evidence that is capable of supporting such a prejudice. However, parties will find themselves in their own bargaining positions and having different bargaining powers at the contract negotiation stage, and they can fight it out between themselves. There are also cascading dispute resolution clauses which make commercial arbitrations quite attractive, and that is the parties can agree in advance or in the middle of arbitration to go for mediation. And if mediation were not successful, they revert back to arbitration, subject to appropriate protection of the continued independence of the tribunal. The choice of arbitral institutions and which set of procedural rules to adopt, and rules of actual procedure within the arbitration, for example, document production and exchange, and the taking of evidence, and those are also attractive options that are available in international arbitration. Next point is that confidentiality is well protected, whether or not a court of law would objectively regard matters to be confidential and worth protection. In international arbitration, everything is confidential, and the parties are under mutual obligation not to disclose the nature of the dispute and any details within the arbitration. Looking to the future, we ask the question, is international arbitration developing towards the right direction, towards diversity or promoting better diversity? There are three aspects to it. The first I highlight is the mode of dispute resolution. Well, different rules are developed to suit the needs of different types of disputes. Rimsky has just highlighted some rules passed to help construction disputes towards a speedy resolution. And there are, of course, rules developed to deal with disputes on domain names efficiently and speedily. And these are all online procedures which seek to deal with smaller disputes more cheaply, more efficiently, without the actual attendance of the parties or their lawyers. I find that the most favored arbitral institutions tend to be progressive and responsive in updating their rules to suit the changing conditions and demands of the market. We are hoping to put together sports arbitration rules to set up a mechanism for sports disputes resolution. And we are also seeing an APEC ODR platform set up by EBRAM to resolve more cheaply disputes which are APEC in nature. Amendments to rules to quickly adapt to market environment is important to keep the arbitral scene alive and ahead of times. And arbitrators would be tasked to conduct the proceedings as cost efficiently as possible without compromising fairness by including parties as much as possible in the design of the procedure most suited to the circumstances. The level of rigor of these rules would sometimes depend on how aggressive or cooperative the parties may be towards one another. And there is an increasingly strong tendency to ensure mediation is given a chance in the private dispute resolution process. Capacity building over the years have made available to the market mediation professionals, a strong body of them, of effective mediators seen to add value to the process. Right at the beginning of making mediation popular, we see that not a lot of professionals really know how to do it. So they were just sort of going through what they should go through generally, and they're not seen to add a lot of value. But after a few years down the line, we are seeing much more of a body of effective mediators to rely on. And that, in my view, adds significantly to access to justice. Diversity in format, I would quickly mention blockchain technology and ODR processes used currently in Hong Kong. The EBRAM APEC ODR platform is one of them. And we can see more of ODR, online dispute resolution platforms, emerging in the future. Now, I wouldn't go back to the point, which is very often rehashed, of the popular nature of online hearings now. It is now prevalent in international arbitration. 3-4 years ago, I would still be hearing arguments from counsel saying that we must not have a video conference hearing because it is against the agreement of the parties, but now no longer. Quickly, I would mention diversity in arbitral panel. Why is it important? A 2021 survey shows that 37% of respondents thought it does not matter at all. 56% thought it matters a great deal, the diversity in the constitutional panel, and 36% thought that it matters. But where are we lacking in diversity? There are gender, racial, ethnic, geographical, cultural diversity, and diversity in training and background. Well, if we think about picking jurors, for example, it's not like picking jurors, because for commercial arbitration, there needs to be a certain degree of expertise, otherwise it's easy to get it wrong, in which case finality means that there's no way of overturning it, or very limited means of overturning it. So it is about a certain degree of expertise, and then on that basis, you try to build diversity. But it is not just about gender diversity. We have to understand what causes the lack of diversity and inclusiveness in the first place. And that could sometimes be the overvaluing of experienced or well-known arbitrators. And there is a deep sense of insecurity of choosing the wrong arbitrator and wanting to fall back on a safe choice. Next, there is asymmetry of information in the market on qualified arbitrators who are not well known. And there is a lack of transparency in awards informing professionals of the quality of a certain arbitrator. So all in all, I'm confident that in building capacity and making commercial arbitration more popular, there will be more information about arbitrators that would promote greater diversity amongst arbitration panel members. In 2021, Hong Kong IAC appointed 44 arbitrators, which was over 30% of all arbitrators appointed who were not appointed over the past 3 years. And that is a very commendable effort to make the arbitral panel more diverse. Now, who can make a difference? It is the parties, their in-house counsel, their counsel teams, arbitral institutions. And all of them will have to be aware of the of the positive qualities of a diverse arbitration panel. Diversity is free structure. Rimsky has mentioned funding of commercial arbitration and mediation. I would like to say a little about outcome-related fee structure. As Rimsky has pointed out, the recent amendment bill seeks to provide some more flexibility in free agreements between parties involved in dispute resolution outside the system of public administration of justice. There is already, this outcome-related fees is already permitted in a number of major jurisdictions. China has been very comfortable with it. Our China counterparts, mainland counterparts, they are very comfortable with outcome-related fees. They've always had it in their litigation, arbitration. And in fact, to not have such an arrangement possible in a jurisdiction like Hong Kong will, no doubt, hamper the development of Hong Kong as an international commercial arbitration center. In my view, it is market-driven need which is likely unstoppable, and Hong Kong should rise to the challenge, lest it is left behind. It is somewhat disappointing to learn that recently when the Law Reform Commission committee went to LegCo to try to explain the bill, it was not very well received amongst the legal sector of our LegCo representatives. It could be a result of a lack of familiarity or understanding of how it operates. But basically, the argument was that we don't know how to play the game. We don't like it. That was basically the message. That is very, very disappointing because, well, legislators may owe their seats to people who elect them, but I think they owe it to Hong Kong to let us progress and develop as an international arbitration center. And I think the ORFS will be significant in that regard. So thank you very much.
I'm sure you'll join me to thank Winnie for the excellent presentation. All the topical issues that a lot of our participants have in mind have in fact been covered in Winnie's presentation. So we can tick off a few of the questions that have been submitted after your presentation. But given the limited time we have, without further ado, a number of questions have been submitted either online or by participants. So I will proceed to the Q&A session. And our panelists will forgive me for diving straight into some of the topics that a lot of our participants have in mind, because there's actually quite a bit of overlap in the questions that have been asked. Can I start off with this? One of the questions asked is, promotion of the rule of law amongst the general public is one of the important initiatives of the government. Now, as arbitration proceedings are conducted in private, details as to how arbitration is conducted and the results are generally not available to the public. In your view, how should the arbitration industry participant attempt to promote the rule of law to the general public by participating in arbitration? Now, the chairman of the HKIAC will forgive me for directing this at you first, but I'm sure you have been asked this question in the past. Rimsky.
Victor, thank you for the question. I think it's a very good question. Actually, it's been asked in this manner as well as in slightly different manner. Perhaps to begin with, confidentiality is, of course, one of the cornerstones of arbitration, but it doesn't mean that information about arbitration is totally lacking in the community. In some jurisdictions, some arbitral institutions publish digests of arbitral awards, just like cases. Of course, you won't find the names of the parties, you won't find the details which enable you to second guess who are the parties in the disputes, but these are one way to deal with the situation. And since you asked me in my capacity as a co-chair, allow me to do this commercial. Actually, last year, the HKIAC put forward a new platform called the HKIAC Case Digest. It set out the past decisions by the HKIAC on decisions relating to the implementations of the rule as a summary, so that you know how the rules are being implemented. And in fact, we got the World Arbitration Award for rolling out this HKIAC Case Digest. These are perhaps the more technical or logistical solutions. But another way of looking at the matter would be, I think it's for the arbitral community, particularly the practitioners, to go out and explain what exactly arbitration is. Because in some instances, in some jurisdictions, in some sector, this issue has been raised and quite seriously, if I may. And that is, they see a sense of secrecy behind arbitration, when in fact it is not. So I think the arbitration community has a duty to explain more to the outside world, not just the in-house counsel of big enterprise, but to the community generally, the rationale behind arbitration, as well as the benefits that can be brought about by both domestic and international arbitration. Thank you, Victor.
Yeah, thank you very much, Rimsky. Now, the questions keep firing in. I will continue. I've been asked to direct this at Robert. How do you think online dispute resolution may change the ecology of dispute resolution mechanism? I mean, do you envisage that face-to-face arbitration, mediation, or even litigation may gradually be replaced by online means? I mean, we all know the HKIAC has done a great job in moving disputes online. We have all done hybrid or hearings that are fully just on the internet. But what is the recent trend and what is your experience? And what do you think is going to happen?
Online hearings are, of course, very convenient. But I'm not convinced that it is going to replace face-to-face hearing, which has other advantages. For example, if you have a panel of arbitrators, they will be together. And when you are in the room with counsel for both parties and the parties, I think it's much easier for there to be interaction between them. Internet hearings are useful because often you have witnesses who are scattered around the world, and because of COVID, travel has not been easy. And of course, there are, even without COVID, there are witnesses who are not vital to the resolution of the dispute, but who are nevertheless important witnesses. And it could cut away time and expense if they don't have to go to the place where the arbitration is held physically. But on the whole, I believe face-to-face physical hearing is likely to continue, especially in the more substantial arbitrations.
Thank you very much. Now, and of course, over to Winnie now on the topic of diversity in arbitration panel. Now, the participant said that there's a tendency to nominate well-known arbitrators rather than spending time to make inquiries about someone that you have never worked with. Now, in your view, how can the Arbitration Institute assist lay client to pick the right arbitrator? What can be done? Do you think we can set up some sort of KPI for arbitrators, have more information on the objective information on how good or how bad they are? Any views on this?
I think arbitral institution play an important role in that, for example, in appointing a sole arbitrator or the president of the tribunal, the work of the appointments committee would involve shortlisting suitable candidates. And that, of course, will have to be a list, suitable in the sense of legal qualification, amount of experience commensurate with the size and nature of the case. And sometimes you also have to look towards what sort of co-arbitrators have been appointed. Now, in that regard, for example, if the parties have appointed very experienced arbitrators as co-arbitrators, then the arbitral institutions will find itself constrained to appoint a chair of commensurate experience, lest the chair would be lacking in authority. Now, if the parties would be prepared to research into suitably qualified arbitrators who are prepared to work hard, prove themselves, and at the same time will have the guidance of the chair, then that would be a different game. So as I see it, all the council teams, the parties, and arbitral institutions all have to work together in order to ensure a thriving and ever increasing number of arbitrators in the pool in order to facilitate administration of justice in the international arbitration context.
Thank you very much, Winnie. Now, a question just came in about mediation, and I will direct this at Rimsky. The chief executive has announced to further promote the culture of mediation in the policy address. What is your view on how to encourage participation of mediation in different sectors, and which sector may benefit the most from utilizing mediation?
Thank you, Victor. I think mediation, if you look around the different jurisdictions in the world, whether common law jurisdictions or civil law jurisdictions, mediation has been used in many different sectors and different areas. In Hong Kong, I think so far the use of mediation has been primarily in civil disputes. For instance, matrimonials and say small claims disputes. But I think there is room in Hong Kong to further enhance the use of different types of mediation. What we need is the mediation community should go out and promote mediation. At the same time, I think facilitation by the government would also assist, such as providing more course, more training to people who will be qualified in the different areas of mediations. For instance, I can give you one example. In some other jurisdictions, there are mediators in the schools, in the high schools, and the schemes turn out to be extremely successful, not only allowing seniors in the school to mediate disputes among the juniors, but it actually helps to promote the upbringing of the kids in the school. And another example I can give in terms of variety is that in Hong Kong or in many common law jurisdictions, mediation is not used in criminal related matters. But in some jurisdiction, in the less serious crime, mediation also has a role to play. So sky is the limit. It depends on how much resources we can get to further explore the use of mediation in the many different areas that we can have in the community. Thank you.
Thank you very much. Now, I won't be able to finish all the questions, but let me pick a couple that is more interesting and less discussed. Now, Robert, I'm sure you have heard arbitrations where the governing law is not Hong Kong law, English law, and you have lawyers making submission in front of you that are not qualified to practice in that particular jurisdiction. So you have English lawyer making submissions on continental European law, PRC lawyers making submissions on English laws. We have experience of that. Contrast how we do it in court. Foreign law is a matter of fact, of course. I think you've written a judgment on that. Which model do you prefer, and what is your experience in that regard?
Well, very often, if a matter of foreign law is involved, there will be expert evidence on foreign law. But when it comes to commercial law, I'm not sure that there is really that much difference between Hong Kong law and say Chinese law. The details may be different, but the thinking behind it is the same. And the approach to the legal problem is the same. So it's never been a problem so far as I can see it.
And Winnie, do you have some experience as advocate? I'm sure you have argued cases. I know you have at least argued cases based on PRC law, so you can share some of your insights on.
Yes, we do, and we always do it with lots of help. So even if an advocate is only an advocate conducting the advocacy is not qualified in the law of that jurisdiction, it doesn't mean that he does not have help in supporting his submissions. So I have frequently drafted all the sort of Hong Kong law submissions for another team of counsel from America or somewhere else for him or her to advance without me appearing in the arbitration. So it would be in their interest to have lots of help. So it doesn't mean that they would advance submissions that are necessarily incorrect. And in any way, all the submissions are well reasoned and backed with authorities, which the arbitral tribunal can duly assess. And often, if it is a case involving foreign law, there would often be at least one member of the tribunal who is familiar with the law of that jurisdiction. So in that sense, it also helps ensure that the arbitral tribunal gets it right.
Thank you very much. Now, we're running out of time. Finally, I have a question from a young lawyer who wants to go into arbitration. He said he's finding it difficult breaking into the market. He's not well known. Where are the opportunities? So I think all three of you, please chip in, because the person who asked the question sounds pretty desperate.
Wait, may I go first? Because I've often had to give this advice. So, well, I work very hard on the appointments committee to try to draw attention to younger qualified arbitrators. But I think the younger candidates have to help themselves as well. I think, first of all, you have to get the right qualifications, get the memberships of the institutions like the Chartered Arbitrators, Chartered Institute of Arbitrators, etc. And then you have to be seen in the circle, in the sense that you have to let people get to know you better as somebody who, say, have the opportunity to speak on a topic. And that you can do via whoever you practice with, either in a firm or in barristers' chambers. It is better for someone to have heard you or to have noticed your existence, for a start, to know your expertise, to know that you know a certain area of the law. And that would add to the attention paid on this person as a potential candidate. Arbitral institutions are, well, at least the HKIC is very good at it, always looking for potential candidates to appoint. And of course, once you break into the market, so to speak, for the first time, gradually there will be more cases. And the low-value cases are absolutely perfect for trying out new arbitrators. So it is not entirely hopeless, but you have to work very hard on it and not over-represent your own ability and experience.
Thank you. I think the young person also want to hear from Robert specifically, because in giving advice to young people, they're looking at the most senior practitioners here.
Well, I think if one is really interested in arbitration, one may wish to begin by acting as secretaries to arbitral tribunals. I think that is normally the best start. Otherwise, as a young lawyer, one should not expect to be appointed as an arbitrator too early in one's career, because you can look at the appointment of judges, say appointment of district court judges. There's a certain minimum years of practice before one becomes qualified. But the fact that the qualification will be set at 5 years or 7 years doesn't mean that a person who's done 5 or 7 years would be appointed. It takes time because being an arbitrator is I think carries with it a very heavy responsibility. So I would suggest that they start by becoming secretaries to a tribunal. In order to do that, they have to, of course, make known their interest. And I think the best way to do it is to come to know some BC arbitrators, and hopefully they will become noticed and then eventually appointed.
Thank you very much. I believe our time is up. So on behalf of the panel, can I thank the Department of Justice again for organizing this conference and putting this panel together. And I'm sure all of you will join me in thanking our 3 distinguished speakers.
Thank you. Definitely also a big round of applause to our fantastic moderator, Mr. Dawes. Thank you so much. So now I would like to invite our moderator and our 3 distinguished speakers, please remain seated and look at our official photographer right in front of you to capture this important moment. What an inspiring and also wonderful section we had just now. Once again, ladies and gentlemen, a big round of applause to Mr. Dawes, Justice Tang, Mr. Yun, and Ms. Tam. Thank you so much. Please be seated. Here wraps up our second panel section of today. And before we proceed to the third panel section, we will have a 15-minute break. So please enjoy the refreshments in room N204 to N210, which is opposite to this conference room. And also remember to return to this hall before the start of the third panel section. The starting time of our third panel section will be 3:45. So enjoy the refreshments, and for our online participants, please remember you don't need to log out from the system. So see you all in 50 minutes. Have a wonderful refreshment. Thank you. Ladies, gentlemen, good afternoon. We shall resume our third panel section shortly, so please kindly make your way back to the conference hall. Thank you. 咁多位嘉賓，我哋咧即將開始我哋第三場嘅專題研討環節啦。咁所以咧，我哋有請喺會場外嘅嘉賓啊，立即咧移步翻嚟到會場入面嘅位置啦，同我哋參與最後一場嘅專題研討。多謝咁多位。Ladies and gentlemen, good afternoon. We will resume the third panel section now, so please kindly make your way back to the conference hall as we would like to start the panel section as soon as possible. Thank you. 咁多位嘉賓，我哋第三場嘅專題研討咧，立即就會開始啦。想喺呢個時候咧，邀請喺會場外嘅嘉賓啊，立即移步翻嚟到我哋會場入面嘅位置，咁等我哋啦可以立即開始我哋嘅專題研討環節。唔該晒大家。Hello， 咁多位嘉賓，大家好。喺呢個時候咧，
喂，冇聲嘅。Ladies and gentlemen, good afternoon. Now let's start the last panel discussion session. Today, we are very happy to be at this Rule of Law Congress, Rule of Law and Justice for All. This is the last panel session. Now, this morning at the opening ceremony, the Secretary for Justice said that this is going to be a very special panel session. Today, apart from experienced scholars and experts who will share their insights on different topics, in this panel discussion, we have invited some young people to share their views. So this is the last panel session. The name is Community Commitment to the Rule of Law, the role to play of our younger generation. We're happy to have the following guests. Ms. Sharon Tam will be our moderator. Let's put our hands together for Sharon. And then we have a number of panelists. They are Mr. Kelvin Chang, Ms. Angel Wong, Ms. Glenda Tan, Mr. Lim Sanshin, Mr. Jason Zhang, and Mr. Li Xiaodao. Welcome. Welcome, panelists. Now let me pass the floor to our moderator, Sharon. And before that, let me remind you, both on-site and online, that after this panel discussion, there'll be a Q&A session. If you have any questions, you are welcome to write down your questions and hand them to our crew members. Or you can also scan the QR code that will appear later, and then you can input your questions to the Q&A system. For online participants, you can input your questions directly to the chat box. Our speakers, our panelists, will answer your questions during Q&A. Without further ado, I can see that our moderator, Sharon, is already very anxious to have this dialogue with young people. So Sharon, over to you, please.
Distinguished guests, ladies and gentlemen, welcome to the last session of the Rule of Law Congress today, and also the very final session of the Legal Week, which is organized by the Department of Justice. I'm very honored to be invited to be the moderator of this session. And to give a bit of my background, I'm actually a Hong Kong practicing solicitor with an international law firm and also the vice president of Y Legal Lights, which is a young lawyers platform dedicated to the rule of law promotion to the young people as well as the general public. I would like to rewind a bit to last week when I was preparing this session together with all the young speakers. I was actually repeatedly told that this session has received a lot of attention from many people, including, of course, the organizing team of the DOJ and also the Secretary for Justice, as he has remarked this morning in his opening speech. And actually, needless to ask why, I think it is fair enough that nowadays it is very important, and we are always very keen to listen to the voice of the young people nowadays. And by looking at the topic that we are going to discuss today, we actually see three key elements. And first of all is the rule of law. And this is something, well, to many sounds like very grand and not very easy to understand. But at the same time, someone may find that it is quite simple, and at the same time, it is quite complicated. When I say it is quite simple, it is because many of us actually know that the rule of law is actually the cornerstone of Hong Kong's success. And I have also heard from many youngsters saying that 當佢哋睇電視劇嘅時候
when they watch TV drama series, when there's a quarrel between two parties, people will say Hong Kong is placed with rule of law.
level, the term 法治 is actually known and very familiar to many of us. And of course, at the same time, there are also a lot of core elements that are always here in the concept of the rule of law in Hong Kong, such as everyone is equal before the law, independent judiciary, as well as everyone must obey the law. But I'm not going to elaborate further here, and I will defer this discussion to all the young and talented speakers later on. And by looking at the topic, we have the second and the third element. The second element is community, 社區, together with the third element, that is the young generation. And actually, I do think that when these three key elements putting together, they make a perfect match. It is because, although young people being young, it may not be an advantage in terms of maturity and experience, but actually, in Cantonese, 年輕新一代, when we talk about 輕, it actually means light in English. So, young people, we do not have any baggage, we don't have any burden, and so we can be more straightforward in sharing what we have been thinking. And also, young people is very good at learning, unlearning, and relearning. So we always pick up things very quickly. And young people, they are very innovative, creative, and indeed, they are very close to the recent trend and the development of the society. And all these good qualities actually are very conducive to the promotion of the rule of law in the modern world and to the community. So probably young people, they are actually in quite a good position to give suggestions and recommendations on how to bring proper understanding of the rule of law into the community. And we can also give some good suggestions on how to do it in a more effective way, as the concept of rule of law evolves with the development of the society. And we always need to accommodate new elements in the rule of law promotion and education. Given this session is really the finale of the legal week, and we have a lot of bright and young minds getting together here, we really hope that this session can be more relaxing, just like 後生仔傾下偈. And in fact, just like similar to what Hong Kong is, we have people with diverse background here, and so it will be conducted quite differently from all the previous session, and we would like to have all the speakers free to choose their own language in sharing what the rule of law means to them. 所以咧，今日咧，其實
So today, for this panel discussion, we hope to conduct it in 3 languages. Our speakers will use different languages, including Cantonese, Mandarin, and English, to discuss with you how rule of law can be incorporated into the community.
I'd like to take this opportunity to briefly introduce all the speakers to you. And today we have Kelvin here. Kelvin is actually a good friend of mine, and we have been working in the Law Societies together for many years. He is a council member and the chairman of the Young Solicitors Group of the Law Society of Hong Kong, and now he is a partner of Yong Yu Yun and Co. And also, we have Angel here. Angel is a practicing barrister and also the vice chairman of the Young Barristers Committee of the Hong Kong Bar Association. And today we have Li Xiaodao. Li Xiaodao is actually a PhD candidate of the University of Hong Kong, and he's going to share with us how they view the rule of law in Hong Kong from a Hong Kong drifter's perspective. And today we are very honored to have Glenda and also Xin Shan, and they are actually have just arrived in Hong Kong like 2 days ago, and thank you for flying over in order to join this conference. Glenda is a law student with the National University of Singapore, and she is also the best presenter in the International Youth Legal Exchange Conference in 2021, while Xin Shan is the chairman of the University of Malaya Young Leaders Association and has earned the Best Paper Award in the International Youth Legal Exchange Conference in 2021. And last but not least, we have Jason here. Jason is actually the young local entrepreneur, and he has his own startup specializing in education technology. So without further ado, may I now invite Kelvin to be the first in sharing? Kelvin, it's over to you, and thank you, everyone.
Thank you, Sharon, for your introduction. Secretary for Justice, distinguished guests, fellow panelists, ladies and gentlemen. I'm very delighted that DOJ has offered me an opportunity to share with you my views on the rule of law, and also to share some of our experiences in the Law Society of what we have done for the community in involving the community on educating them on the rule of law. When I was invited to speak on this topic, the first question obviously came to my mind was, what is the rule of law? And the first thing that came to the top of my head was, well, everyone is equal before the law. And the obvious principles that come from it is that the law applies to everyone. The laws are not arbitrary. The laws are enforced fairly, and the judiciary is fair. And given that guideline, in my feel and thoughts, I believe that an independent judiciary is the key and cornerstone to whether we have a strong rule of law. And that is the reason why, as a lawyer in Hong Kong, I have a very strong conviction that the rule of law in Hong Kong is very strong. However, that is not what I see in media, especially in international media, where we have come across comments where they talk about Hong Kong's rule of law eroding. And that brought me to the next thing that came into my mind was, is it because my understanding of the rule of law is different than anyone else? And so I started speaking to people within my profession and also outside my profession and asking them, what is their feel and thought of the rule of law? And the answer came out quite unsurprisingly, actually, and it is that everyone had a different interpretation, different meaning of the rule of law. And so, to me, everyone's way of saying rule of law is different, and there is nothing universal about what really the general public's feel of what the rule of law is. Given the arbitrariness, out of a lack of a word for it, of the term, I then turned to the online sources to see what the rule of law could be. And when I obtained from sources of what the rule of law could be, I came up with ideas of security, freedom, rights, all of which are concepts that differ from my belief of what the rule of law is. I mean, they are good points to consider for the community as a whole, but they are rather remote to when we speak about the rule of law. So this leads me to consider my first point, which I want to share with everyone today, and that is, how can one judge another's rule of law? If a term like the rule of law is so arbitrary and not universal, then how can the rule of law of a particular jurisdiction be assessed? What elements are used in judging the rule of law? When the judges are assessing the rule of law, what are they basing it on? Can there be a perfect rule of law? And this leads me to the very, very obvious question. Can the rule of law exist not just in a democratic society, but also in a non-democratic society? Can the rule of law exist not just in a common law jurisdiction, but also civil law jurisdiction? Obviously, I'm not here to discuss further on this, but what I want to spark is just an idea, a question, a wonder, whether we can truly and justifiably assess someone else's jurisdiction's rule of law. And in my belief, I believe that there can be rule of law for both non-democratic societies as well as civil law jurisdictions. And I believe that only the citizens that are living in that community can judge and assess their own rule of law. Now, under my interpretation of the rule of law, obviously it goes without saying that it is very, to some people, a narrow interpretation of what it means. And I find that there are people that are looking into what good laws and bad laws are, and that actually puts an impact on how they feel the rule of law of a jurisdiction is. But to me, they are two separate concepts. And so, in my opinion, I want to also raise this out, is whether these two concepts should be mixed together or whether they should be separate concepts to be considered. And so to me, when it comes to educating the public on the rule of law, I think the critical thing that we need to impress upon the public is how our legal system works. Because the more educated, informed people are about our legal system, the more they can actually get themselves to know whether they can separate the concepts between the rule of law and the political way of affecting what the rule of law is. And here I would like to share what the Law Society has done in respect of community involvement. In the Law Society, we have had a flagship event called the Teen Talk, where we involve the community, especially the high school students, in dealing with particular legal topics every year and helping them in involving and getting them to understand the various legal topics that we have in Hong Kong. Oops. So you can see on the slides that there are all the themes that we've had all over the past years, all are very interesting topics. Over the 10 years, we have actually had more than 15,000 students in the aggregate involved in this. And I believe that this is for a greater cause of the public, and so we must continue on with it. And this event has grown bigger and bigger over the time. You will see in the photos that we also have distinguished guests come in to actually share their views every year. And it is very fortunate for us to be able to arrange that. You will see there's also opportunities for students to go to legislative building to actually have mock debates on legislative bills. Previously, we also have trials at high courts to have mock trials as well. And so these are experiences that I believe that the Law Society has afforded to the students over the years to help them gain an understanding of our legal system and the rule of law. For the last year of the Teen Talk, we actually had a flagship event of having to arrange the visit of the various disciplinary forces. And so students were able to go to these disciplinary forces where areas that are typically not open to the public. And they got to experience the various things and actually have them see them in action, having a fire and having to be able to take out the fire. And so this is something that we will continue on, and I believe that we will stay strong on this and continue to help the public on this. The next initiative that I want to mention is actually something that is for a brainstorming purpose. And this is something that under the Young Solicitors Group, we have done so for the past 2 years. And this is something more of a treasure hunt game, but hopefully using a game version to help people break the ice, know their own members more, in particular between the young practitioners and the senior practitioners. And you will see in the slide that they take pictures. What happens is there's a riddle, and they solve the riddle amongst the group. Once the riddle is solved, they will know where to go, and they will take photos. And then once that photo is taken, it goes to the game master, and throughout several weeks, they will then end up having a winner who has won it best in terms of the event itself. So this is something that we have implemented so far in the past 2 years, and I hope that this can actually be implemented in the community-wide, such that we can perhaps have groups with various ages, various industries put together so that people can actually hear different perspectives, and they can be exposed to things that they normally wouldn't be exposed to if it is not for the event. And that sums up pretty much what I want to present today. Thank you very much, DOJ, once again, for allowing me to share my views today. Thank you.
Thank you very much, Calvin, and thank you for introducing us Teen Talk as well as the scavenger hunt that was organized by the Law Society of Hong Kong in promoting the rule of law, not just among the young generation, but also among the young lawyers. And just to mention in passing, I recall the group that I belong to actually was the champion in the scavenger hunt last year. So yeah, I was very happy about this. 好，咁我哋而家咧就有
Okay, now let's invite Angel to share with us the Bar Association's initiatives in promoting rule of law. Angel, please. Secretary for Justice, guests, ladies and gentlemen, On behalf of New Barrister Committee, I would like to thank the Department of Justice for organizing the Hong Kong Legal Week and for inviting us to join so that we can share our work. And I am very honored as Vice Chairman of the Young Barristers Committee to have this opportunity to make this presentation today. I'm happy to have a discussion with other speakers on rule of law. Without further ado, let me give a brief introduction. So, what is the work of our committee? The Standing Committee on Young Barristers has another more well-known name, and that is Young Barristers Committee. So usually we call ourselves YBC. So later on I will tell you what YBC has done. Every year we have around 20 to 25 members. They are young barristers, YBs. So young barristers are those barristers who are within 7 years call in their career. So they are young barristers. The objectives of our committee is to provide a platform for exchange of ideas amongst YBs. And on behalf of YBs, we will promote and represent their interests and welfare. And between YBs and the more senior members of the profession, we hope to see better communication. But these are not the only objectives. As a member of the legal profession, we know that rule of law education is very important. There are two other key points. First, there is the need for popularization. Why? Because very often we are trained about laws, but very often we will overlook the point that this system is very unfamiliar to members of the public. For example, when people deliver free legal advice or serve as duty lawyers, then, they will come across members of the public who know nothing about law. They don't know the court proceedings, and they don't know the court etiquette. They don't know what their rights are. Since they don't know, then of course they are not able to discuss further concepts. They are not able to grasp abstract concepts. So whenever they have to face legal proceedings, they will be very scared. So we hope that law is not something very remote to people's lives. We hope that people from different sectors will understand more about the operation of our judicial system and what their rights are. Only in that way can people have further discussion. Now, rule of law education has to start early. When young people are in school, we hope that they can make use of their school time or extracurricular activities time to come into contact with this concept. Now, after getting to know this concept, some young people may think that, oh, law is good. Then perhaps our legal profession here in Hong Kong can take in more talents. So now I will share with you more about YBC. We have different subcommittees, and there are two subcommittees which have organized related activities. First, street law programs. What is street law? Street law is an emerging legal education item. So the emphasis is to make use of innovative and interactive way so that members of the public will have some desire to gain legal knowledge. So we hope that they will really want to know what rule of law is and what our laws are all about. So this is an outreach subcommittee. And it cooperates with an organization called Street Law Hong Kong. It is a new enterprise in Hong Kong, hoping to promote rule of law education to the public. At the end of last year, the two parties worked together in a secondary school in the New Territories. So a workshop was organized for all students there. Then what was done in that workshop are talks delivered. That is not only that is not the only work. For example, games are organized. We played games with the students. So that is called the Mars mission. So what does that mean? By landing on Mars. So, okay, let's say if we need to go to Mars, then in different areas of the Earth, we have to gather together some supplies and resources. But then time is tight because you need to travel to another planet. So we group students into various groups, and they have to compete to collect materials and supplies. When they tried to collect materials and supplies, they have to set rules for different groups. For example, the group will say, oh, for the next group, they will have 10 seconds less. Or for the next group, they cannot use their hands to pick up things. They have to use other ways. So after laying down all the rules, all students have to follow the rules. But before you raise those rules, you won't know whether you will be subject to these rules. So why do we want to play these games? Because we want to tell them the functions of rules and how are rules derived. So what kind of rights do they find most important? So we will take those opportunities to instill rule of law concept into them. After that mission, we have led students to visit the former Fanling Magistracy, and YBC members served as tour guides. So we toured the magistracy, and we told them the proceedings in magistrates' court so that they have proper understanding. Sharon just mentioned that people watched TV series, and people will say that Hong Kong is a society with rule of law. However, the court scenes in drama series are often exaggerated. So we told students that our students the operation and the way how courts function. Now there is also a simulated court summer school in order to explain concepts to them. So in the coming years, we believe that we will continue these street law programs. Apart from knowledge, we need to offer students a platform for them to discuss topics related to law. So now let me tell you something about our annual event, and that is the Hong Kong BA Debating Competition. We have organized this competition for many years already. Now, the debate topic is related to law. Besides, we invite judges and barristers to be adjudicators for the competition. So students can listen to comments from the legal professional perspective. Besides, they can also have exchanges with legal professionals, and they will gain a lot of insights. They will have the chance to express their views. At the same time, there is chance for communication. So these are some examples on how YBC delivers rule of law education. In the future, we will continue to work towards the same direction. Thank you. Thank you, Angel. Thank you for sharing with us the work of Barrister Association, Bar Association, and what they have done about promoting rule of law. Usually on TV, we heard concepts of rule of law, and sometimes those concepts may not be totally correct. So we really rely on our two professional bodies to deliver the right understanding and interpretation of rule of law and pass on knowledge to the new generation.
Our next speaker is Li Xiaodao. He's a PhD candidate from Hong Kong U. He's going to talk about the mainlanders in Hong Kong, what is their understanding of rule of law, and how the mainland students, how to help with the promoting rule of law. Mr. Li, please. Dear distinguished guests, good afternoon. It is my great honor to be here and I share with you once again. So the topic I'm going to talk about is the necessity and construction of a legal belief. So this is the content I'm going to talk about. 3 parts in my presentation. First of all, why the mainland students should care about rule of law in Hong Kong. Secondly, why mainland students need to constitute a belief on Hong Kong's rule of law. And number three, how to construct such a belief on rule of law in Hong Kong. Now let's look at the first one. The very simple answer to the first question is that because it affects mainland students quite a lot. So I want to establish it from the constructivism. So what is the role and what is the identity for the mainland students in Hong Kong? So let me give you an example. I believe that you may have already played or heard about Mahjong. So if there's no rule of Mahjong, then there won't be existence for such a game, because you have rules to play, you have rules how to play. Without if know this, you don't know who will be who is your counterparty and how to win. So therefore, for the rules themselves, they can constitute the benefits and identity for all the players. And similarly, for the mainland students, their identities and their benefits are also relevant and maybe affected by the Hong Kong's rule of law. For example, in the Basic Law, Chapter 3, the basic rights and obligations of Hong Kong citizens. But for the mainland students, they are not the citizens here; they are non-permanent residents. So therefore, they have their interests and their benefits to concern about if they live in Hong Kong under such a society with such a law. So therefore, we can say that the mainland students, they care about the rule of law in Hong Kong. But then there comes the second question. Why should mainland students constitute the belief on Hong Kong's law? Now here, I think very importantly, the first point, the legal belief is a very important source of power of law. And let me take this example, Mahjong, once again. When you play Mahjong, the players, no policeman is needed to maintain the order when they play the Mahjong, and when the play is over, and no judge is needed to announce who is the winner. So for any cheating or anything, we don't need a judge to make a ruling on this, because all the rules are well accepted by the players, and if all the rules are recognized and well established, then the effectiveness of the rules will not rely on any judge or any external force for it. That's why Woolman said that a law must be believed, otherwise it will be in vain. So secondly, the law, the mainland students will be affected by what the law is here, depending on their beliefs. So depending on different levels of a law, it will determine how much they get involved into the construction of the society. So as Giddens said that, so this system needs a space and a time in order to realize the social practice. From this perspective, the rule of law in Hong Kong is not something that you write on the paper or in a brochure or a slogan that you can call out. It is something that it is implemented and established that goes beyond the time and space, something that it is a kind of a social practice from a legal perspective. Being a member of the society, mainland students living in this society, how they think, how they practice, also relevant to how the rule of law is established in Hong Kong. And mainland students, they have very special identities, and in terms of space and time. In terms of space, a lot of mainland students, they may turn out to be permanent residents here in the future, and they may continue playing their role in the society here. Their belief, their practice may also present continuous influence to Hong Kong's rule of law. And in terms of space, so mainland students, they have their own social circles in Hong Kong and in mainland. And in terms of legal practice, they can also play their role to influence their circles in both places. So therefore, for mainland students, if they want to be more effective, they can promote the rule of law in Hong Kong in both spaces. Now, After answering the first two questions, now let's look at the third question, which is also the last question: how to build up your legal belief for Hong Kong's law. Let me ask you a question. So by throwing out three paths here, the first pathway is to construct your own identity. You have a sense of belonging. Now, once again, let's look at mahjong. If a person doesn't play mahjong, there's no chance for him to sit in a table. Then he's not motivated to learn about mahjong unless he's invited to speak at the legal week and to improve the significance of this mahjong game. So for a member, so the sense of belonging and a sense of recognition helps with the understanding of the rules of the society, as well as the willingness to understand the society. And most importantly, from the floating population point of view, they're a floating population, and in the future, they will be a local resident, they will be a citizen in Hong Kong.
As many scholars suggested, the identity of Hong Kong is a culture concept. Whatever the background and the language they speak, as long as they believe they are Hong Kong people, they are Hong Kong citizens. This kind of the identity could help them to get the knowledge on the rule and accept the rule of law in Hong Kong. The key point here is to figure out the connection between the rule and law and the shared interest of the society, which will play an important role in consolidating their rule of law awareness. At the micro perspective, from the three layers issued by words, they could mimic the law-abiding activity and give the positive response to the law-abiding activity and the negative feedback to law-breaking activity. Through peer pressure, they could influence others. This is my brief presentation of my three ideas. Thanks for listening to that, and I hope we could make the best to contribute the rule of law development. Thanks very much. It's quite interesting. We haven't figured out the perception of rule of law from structuralist and the words idea. I believe is quite eye-opening for most of us, and thanks for giving us the new idea.
Representative, may I now invite Glenda, who is a representative from Singapore, to share with us your insight on how to promote the rule of law in Singapore with us. Thank you.
Hello. Okay. Good afternoon, Secretary of Justice, distinguished guests, and fellow panelists. I'm very honored to be invited to speak today. And today I'm going to talk about some efforts that Singapore has made in terms of encouraging the rule of law and youth engagement in the rule of law. To this point, the presentation will have two parts. Firstly, we will talk about Singapore's stance towards the rule of law in the introduction section, as well as talk about the schemes that Singapore has used to engage youth, namely the mandatory pro bono hours requirement, as well as student-led pro bono projects, which has formed a very important part in engaging the youth. Firstly, Singapore has remained very committed to the rule of law. According to our Minister of Law, Mr. K. Shanmugam, he said that Singapore accepts rule of law as the foundation of our nation and that it is a universal value. To this point, the Singapore government has introduced many policies to encourage citizens to participate in the rule of law. Our first scheme that we're going to talk about is the mandatory pro bono hours requirement. Under this requirement, graduates from local law schools have to do 20 hours of pro bono work in order to graduate. For example, I come from the National University of Singapore, and we are required to do 20 hours before we graduate. And interestingly, this pro bono hours can only be logged after the first year of your law school career, which means that you will be able to have some skills, right, to help the local community. And I think this is also consistent with the Law Society's vision that law is a service vocation and not simply just a profession. this program has been rather successful. If you look at the statistics, 85% of individuals have indicated that they will provide pro bono services in the future. Considering that law students now are the future lawyers of tomorrow, this has effectively increased the amount of pro bono work that is being done in society in the future. And you might argue, oh, because it's mandatory, individuals might do it simply because it's compulsory. However, if you look at the statistics, a large percentage, in fact 72% of people, have actually completed more than the 20 hours requirement. It is submitted that this shows that Singaporean youth, through the mandatory pro bono hours requirement, have actually developed a love for pro bono, and this also contributes greatly to Singapore's rule of law. So why has this program been successful? I think it's very much reliant on student-run pro bono projects. For example, I was served as the project director of a pro bono project that basically collaborated with this organization known as the Financial Industry Dispute Resolution Center. So essentially, we were supposed to host workshops in order to educate the public on how they can protect themselves in disputes with financial industries. So we directed them to this organization that does ADR, settlement of such disputes. And I think that was a very fulfilling experience because we got to learn from the ADR professionals, as well as we were able to just, understand what are the problems on the ground. And I think that has made me a better lawyer and has also made me more willing to do pro bono in the future. So I will just talk about briefly 4 characteristics of such pro bono projects. The first characteristic is that it actually involves a wide range of industries, legal industries. For example, I think the most interesting case is for military justice. If individuals are interested in military justice, they can actually participate in the military justice project and help military lawyers protect their clients in military courts. We also have collaborations with very prominent organizations. For example, the organization we partnered with, FITREC, is actually an organization directly under the Monetary Authority of Singapore. And this also allows law students to learn from very esteemed professionals in the legal industry. Moreover, it is student-led and initiated, which means that students are able to take ownership of their project, and this, I think, makes them feel a sense of ownership and belonging to it. The last thing is that it's feedback-driven. While professors, provide feedback, we also get feedback from our partner organizations as well as our participants. And this has allowed us to improve the project year after year. So in conclusion, the mandatory pro bono hours requirement has actually helped the rule of law in Singapore greatly and has greatly engaged the youth. Moreover, student-led projects have been very successful in terms of helping students feel connected to the rule of law. With that, I end my presentation. I thank the DOJ for giving me this opportunity.
Thank you, Glenda, for your sharing. And I think we all really like those student-led projects because it is a kind of empowerment to our young generation so that they can unleash their potential. And in the end, they can contribute back to the society. And for the mandatory pro bono hours, I think we don't really have that in Hong Kong. And maybe it is something that we can consider, right? Thank you, Glenda. And now it's Sin Shan's turn. Would you please share with us how Malaysia actually, in Malaysia, how the youngsters actually promote the rule of law?
Very good afternoon to the Secretary for Justice of Hong Kong, distinguished guests, fellow panelists, ladies and gentlemen. I'm San Shen from Malaysia. So today I'll be presenting on a topic entitled Roles of Youth in Upholding Rule of Law and Promoting Justice. Okay, so these are some of my background. So I'm also a law student and also a student leader. So I would like to talk briefly about the concept of rule of law, because I think rule of law is not just a principle governing one nation or territory, but it's a universal principle that governs us all. And rule of law is important because everyone is equal and accountable by the law. And of course, rule of law forms the foundation to maintain and to regulate the conduct of the people in a nation in order to maintain peace and stability. And not to forget, rule of law is also a key element to achieve the Sustainable Development Goal 16 of the SDG, which are the peace, justice, and strong institution. Okay, so these are some of the key elements of rule of law that can be seen, like equality, independent judiciary, sufficiently clear, prospective, and also stable law, because law should be made known to the public. And also laws are made via lawmaking process, via legislative branch, and also preservation of human fundamental rights. For example, freedom of speech, freedom of expression, freedom of religion, etc., which form the cornerstone of the democracy process, and also access to justice and legal remedy. Okay, so Malaysia's efforts in upholding rule of law are, first of all, in the Article 4 of the Federal Constitution of Malaysia, is stated that Constitution is the highest law of the nation, and everyone is equal before the law under the provision of the equality. And also Malaysia will practice parliamentary democracy and constitutional monarchy, in which we have three branches of the government, namely the executive, legislative, and judiciary. So we don't interfere each other, but we work together to ensure the efficient government. And also we have the independent judiciary and equality before the law. So I would like to cite a case of Malaysia, which is Elma Nudo, a 2019 case, in which the principle is that a central tenet of the rule of law is the equal subjection of all persons to the ordinary law, in which we do not take into consideration the ranking, the hierarchy of the person, but everyone is equal before the law. And also fundamental rights are also protected in Malaysia, in which we have freedom of speech, just like every country, and also administrative body need to act within the ambit of law, okay, which is also part of the rule of law indicator, as you can see. The administrative body cannot act arbitrarily, they need to act within the scope of the law. So what are the roles of youth in upholding the rule of law? I would like to give a definition of the youth first. So in Malaysia, we define youth under the Youth Society and Youth Development Act. So basically in Malaysia, the latest amendment, the age of the youth was between 15 and 30 years old. And the United Nations defined the youth as 15 until 24 years old. So first of all, I think the youth should be actively involved in civil society organization, clubs and society in order to increase their exposure to the rule of law. So in order to do that, they can participate in more programs related to the law, about the nation building, so they can better comprehend the process when they are involving in the process directly. And also this is to provide a platform for the youth to appreciate the importance of rule of law in maintaining peace and justice. Because we know that there's a notion saying youth are the future leaders. But for me, I think youth are not just future leaders, but youth are the leaders of today. Because youth are having a lot of position, leading their student union in their own university. In Malaysia, we have the Youth Parliament. We also have the Youth Consultative Council chaired by the Minister, in which the youth can share their ideas directly to the highest administrative body. So I think youth are the leaders of today and tomorrow. Thus, we need to nurture, we need to groom, we need to build the capacity of the youth to be a well-rounded leaders. Second, I think the youth should be more proactive to become the ambassador of the rule of law, because youth are also playing an important role to become ambassador, to bridge the communication between the youth and also the community, in which the youth can actively organize programs or to engage with the community to spread awareness regarding the rule of law, and also to improve the literacy and understanding of their peers regarding rule of law and also nation building. So how they can do it is basically organizing forum or academic discourse or any discussion that is close to the heart of the youth. They can discuss, among others, rule of law, SDG goals, and also international law, so that people can understand that it's also important for a nation to adhere to international standards and not just making law to the whims and fancy of one country. And also, as an ambassador of rule of law, youth have to know that actions speak louder than words. They cannot simply ask people to follow the law, but they break the law. No, you should set a good example by becoming a role model for all to follow the rule of law. And third, youth should be pioneer. They should start something. They should not wait and see. And they should organize more educational series and advocate for education of rule of law in formal syllabus or education system, because the youth should gain exposure and understanding and more knowledge about the constitution, legislation, international law, national legal system, principle of both common law and civil law, and the rule of law through various workshops and classes. So my idea will be having a mentor-mentee when the legally trained senior can become the mentor for the junior, which are the mentee, so that they can share their experience of working in the legal fraternity and also what is rule of law. So this is what I have done in my association and in Malaysia, in which we form a mentor-mentee group in order to groom and teach the youth, especially the junior, about what is rule of law. And also we organize a lot of programs through extensive engagement to ensure that rule of law is incorporated in our daily life. It is not just very exclusive to a few. And of course, talking about rule of law, we are living in the prevalence of media and technology. So social media also play a very important role in which advocacy and education of rule of law can be conducted via various creative and innovative methods, as shown in this slide. For example, webinar, virtual information counter, and just to share Malaysia, so we have the e-filing system in which lawyers need not to go to court, but they can file their document submission on the e-filing system. And also we have the e-saman in which people can pay their fine via online system and also online hearing. And all these are the utilization of the technology and also social media to promote justice and also understanding of rule of law. So last, I would like to urge all the youth to do comparative analysis on the rule of law indicator. As we know that every year, the World Justice Project will have the rule of law indicator. So as you can see, they will judge the rule of law of each nation based on a few indicators, like accountability of a government, transparent justice system, order and security, access to justice by the public, independent judiciary, and also preservation of fundamental rights. So the youth, what they can do is basically to analyze what is the ranking of their country and the ranking of those countries in top 20, let's say. So they can understand better which part of it that their nation should be improving. For example, Hong Kong is good in order and security, less corruption. So the youth in, let's say, this nation can learn how they can follow the good example set by Hong Kong in order to get a higher ranking and also to improve the rule of law indicator in their own nation. So last but not the least, I would like to have a message for all the youth and as distinguished panelists and also all participants today, in which youth should be regarded as a stakeholder of the world. We, the youth, are the leaders of today and tomorrow. We must take charge now and be proactive in contributing our ideas and effort, as all of us will one day inherit the world, soon, and also slowly but surely. Thus, we must start now in order to better prepare ourselves for the future. As they always say, we need to future-proof. So we need to be active in building a peaceful, sustainable, and prosperous world for us and also for the future generation. So that's all. Thank you very much.
Thank you, Sanchin. Thank you for giving us the Rule of Law 101 in Malaysia's context. And I'm glad to see that all our speakers actually in this panel session today, including yourself, has actually put your points into practice, because we are all the ambassador of the rule of law and we are all pioneering in advocating the education of rule of law at the community level. And we wish to conduct more like community outreach programs. And in respect of digitalization, I think it is more relevant to the last presentation that is going to be given by Jason. 或者我哋而家就請 Jason 去為我哋。
Jason, perhaps you can talk to us about how technology can help us promote just the rule of law. Dear Secretary for Justice and dear guests, I would like to tell you a story. Perhaps you're a bit tired. When I got the invitation to join this panel, I was rather surprised because I have no legal background. So perhaps I don't have enough knowledge to go through what I want to talk about. But then I looked at the topic. I understand. This is what we are advocating, a direction in relation to rule of law and legal concepts, which should be accessible and understandable to people outside of the legal sector. So I am going to share with you how we can help youngsters to understand such concepts so that they can apply it in the future in different industries. Let me ask you when we get started, what do young people think about this term, rule of law? I have interviewed different friends. They come from different universities outside of the legal area. Let's have a look. We have selected a number of adjectives. They think it's boring, it's technical, it's difficult to understand, it's abstract. I'm not surprised. To most people outside of the legal sector, rule of law is hard to understand. Most people can't tell you what it is. So can we do something in terms of education so that we can better understand the concept? Or as reflected on this PowerPoint, the style is a bit different, right? Because we want something younger and also be more relatable to the topic. If we learn about rule of law concepts, which may be technical, we can use a simple way. For youngsters and students, it will be easier to understand. So what innovative way are possible, or digitalized ways are possible to promote this? There are 3 steps. The 3 E's: educate, engage, and execute. First of all, we want young people to help to uphold the rule of law. We need to start with education. I'm very interested in education-related technologies, especially when it comes to interesting topics like rule of law. If we offer something game-related or interesting, that they will be driven to learn more about this. In the past, you can imagine such concepts may appear in textbooks. It will be hard knowledge. Youngsters may not really understand how that is applicable in our daily life. Another panelist also mentioned people have different ideas and interpretation about rule of law if they work in different sectors. Can we simply rely on textbooks? How about relying on educational technologies, offer some games to young people so that they know how to apply the concept in their daily life? We can use simulation games to replay certain scenarios. As panelists this morning talked about NFT, many young people are interested in that. Perhaps we can go through some art exhibition, look at some art pieces. If they can look at the trading of such items, there are many details related to rule of law. This is a great way for them to learn. Next, we can use hands-on experience. As other panelists have already mentioned this, I won't repeat it. We need something interactive for them to get a feeling of it. Otherwise, it's distant concept. They can use personal level experience to better understand the concept. Here are some examples. Perhaps we can allow them to know that in different jurisdictions, there are different principles under rule of law. For example, legal aid, different people with different backgrounds, different economic level, they have equal access and right to obtain legal aid. We can give them some real-life examples. Now, what can we offer? Something not too difficult or complicated. How about we talk about different industries? Rule of law isn't something only relevant to the legal sector. When students grow up, when they work in different industries, it is equally relevant. For example, shipping, logistics, art, exhibition, everything is related. So secondary and university students, they maybe doing some preparation work for the future career. So it is the best timing to teach them about rule of law. There are different stakeholders. For example, you're just a normal citizen, or when you are an employee, what can you do to help uphold the rule of law? Or in the future, when they work for important or large organizations, how do you comply with the principles of rule of law so that we can push Hong Kong forward? Now, as we all know, Hong Kong is a very special place. We have one country, two systems. We have judicial independence. All such concepts can be presented to students in a simplified manner. They can play some games to understand better about the checks and balances. Our ultimate goal, education, is a long process. It can't be done overnight, and it starts with collaboration. We can help our youngsters, our future masters, to understand what they need to do to abide by the law and why. What is the meaning behind that? It's not just about memorizing some knowledge. Hopefully, they truly understand the importance and respect and trust the rule of law. So when they get older, they can help promote rule of law concepts to their next generations and people in their industries. So, as I said, there are 3 E's. Educate is the first one. The second one is about engaging people. Allow them to participate in activities. Youngsters can voice their views. For example, in recent years, we always talk about youth commission, so you can present your views on different venues, provide assistance. And finally, let's talk about execute. That's not for this moment. After promoting education of rule of law, these youngsters will become pillars of the society and they will apply the concepts. And finally, to sum up, we saw some very different adjectives. By promoting such knowledge, hopefully, youngsters would feel the rule of law is something associated with being hopeful, interesting, comprehensible, and relevant. We need youngsters to understand this concept as early as possible, and they have their own roles to play. Before I end my presentation, Lord Bingham mentioned that rule of law or law should be intelligible. So it may seem very difficult and distant, but we still need to bring it to our young people. Thank you. Thank you, Jason, for your sharing. We only have about 15 minutes left, so we will dive into our Q&A session. The first question is for Kelvin and Angel. Someone asked if we have some youngsters who are very interested in promoting rule of law. Do you have any advice for these youngsters? If they want to get involved, what can they do in Hong Kong and also overseas? When I chat with young people, I think when it comes to the definition of rule of law, people are quite uncertain. And it seems to me that when it comes to the phrase of rule of law, it's not something they will discuss with their friends or people around them. So perhaps we need to allow them the space to revisit what rule of law means when they have more life experience. They can come up with their own interpretation, and when they travel abroad, they can discuss with other people about this concept and disseminate the information. Angel, do you have anything to add? Yes. I was just listening to Glenda's presentation. I like it very much. You talked about pro bono programs. If we are talking about law students, while they are still studying, they can participate in more pro bono programs, although it is not compulsory at the moment. Before you have to shoulder a lot in life, participate in such activities. You can provide legal advice after you graduate. I think you can popularize rule of law.
We have a question to Xiao Dao. They want to know, for the mainland immigrants in China, in Hong Kong, how could they play a role in promoting rule of law? Thanks for the question. It's a brilliant question. It's quite connected to my slides. I'd like to quote the 3 words mentioned in my slides. Put it simply, a mainland student in Hong Kong or immigrant in Hong Kong to be a law-abiding citizen is good enough. According to structuralists, Hong Kong's rule of law could be regarded as a kind of legal social practices. Every citizen could play a role in contributing to these social practices and can influence others. So, as long as you could make the best out of your advantage, they are. If you just stay in Hong Kong for quite a short period of time, as long as you respect and abide the rule of law here, that is good enough. If you are a permanent citizen here, you have sufficient time to know the law here, and you can make your suggestions to the rule of law in Hong Kong. That will be good. In this space, you could use the 3 kinds of the social activity. The simulation, positive feedback, negative feedback are all the means that you could mobilize to influence the people around you. Those activities will be good enough to make contribution. They sound quite routine, but just a part of your daily life can make a contribution, can be the channel to make the contribution to the rule of law in Hong Kong.
It's directed to Glenda, and it's actually a very long question, and I try to read out slowly so that you can try to understand it. When was the pro bono requirement for university students introduced in Singapore? Is there any observable change in the pro bono practice, culture among Singapore legal practitioners afterwards? The question is whether the pro bono culture translates from a school context to a work context, where there may be fewer opportunities for lawyers to create their own pro bono projects.
All right, thank you for that question. I think the pro bono requirement was actually introduced, I think, in 2014. It was not a very long time, so there hasn't been a long enough time for us to concretely observe the effect of it. But I do think that there has been a difference in the legal community after it was introduced. So I think the Law Society a few years back has been considering on whether they should include a mandatory pro bono hours requirement for registered lawyers. And I think in the end they decided not to. But right now they recommend that lawyers do at least 25 hours of pro bono. I think in Singapore at least, from my experience, many lawyers are actually very willing to do pro bono. We have things like lawyer clinics and other activities that lawyers participate in. I recall there was a partner in one of the top law firms in Singapore that told me that to her, pro bono was a very important part of giving back to society. So I think to that extent, pro bono has become a very important part of the lawyer community. And so I think the mandatory pro bono requirement does have an effect on legal culture after school.
Thank you, Glenda. 好，下一題呢應
The next question is for Kelvin. Someone is asking us, youngsters and institutions, organizations, well, among them there is a lack of trust. So in terms of policy decision, there is some sort of misunderstanding. So for youngsters who want to promote the rule of law? How can we resolve this lack of mutual trust? That's a very complicated question. I think mainly it comes from education. I think the social mechanism, according to my understanding, or when I was young, I didn't really get it. I thought it's simple. Why isn't it happening? But when I started working in the society, I understand that we can gradually adopt this mechanism in the society. If we can offer them more opportunities, for example, we have team talk inside Law Society, offer them some simulation opportunity, pretend you are the legislator and you are discussing a bill. You understand there is a process, there is a timetable. Such misunderstanding can be resolved.
This question is directed to both Glenda and Senchin. Perhaps this time gentleman goes first. How is the rule of law taught in Singapore and Malaysia? And has it been included as a subject in the elementary or secondary schools?
Okay. Rule of law is taught in Malaysia. There's a subject known as general study. So a basic introduction of the rule of law, like the concept, the national system, as I said, the parliamentary democracy and the constitutional monarchy, and also our constitution as the highest law. All these values will be included in the syllabus. But of course, I will advocate for a subject maybe known as law study, general law study, starting from younger generation. Maybe you can start in primary school, so they can understand the law better, how the law can influence themselves, and also how they can involve in the legal process. Maybe they can go to field trip, visit to Parliament, to see how the bill is presented, tabled, and also debated, to see the full process, like the first reading, second reading, third reading, until the passing of the law, so they can feel that the law will be having an impact on them, and also truly understand the principle of the law. And I will advocate also for a simulation. Maybe they can do like a simulation of the process in the school. Any regulation that involves the student, maybe they can discuss with the student, engage with the student, so to let them know that rule of law is actually promoting democracy and discussion in which between the government and also the citizen. Thank you.
So do the students in Malaysia take this subject very seriously?
Yes, it's a compulsory subject to take if you are taking Form 6 in the secondary school. So this subject is a very important subject. As a citizen, I think everyone is compulsory to know and to understand the law because it governs all.
Okay, it sounds good. How about Glenda?
Actually, we have a pretty similar system. So at least in the secondary 4 level, all students are actually expected to take this subject called social studies. And the social studies actually includes things about how our government operates, perhaps policy objectives. And so through that, they can understand a bit more about the rule of law. But I do realize that at least within the secondary school elementary levels, we do not explicitly mention the subject of rule of law or the separation of powers. In fact, oftentimes it's considered extra reading, and generally people don't take it that seriously. So I think that, at least for me, I was only truly formally introduced to the rule of law through law school. And I think that's a shame because the rule of law is really a fundamental value of Singapore and has been enshrined in the Singaporean constitution as well. So I do hope that Singapore can do a bit more to educate young students about it and ensure that Singaporeans can exercise their civil liberties.
So is there any rule of law promotion program or initiative to the general public in Singapore generally?
And not that I know of. So generally what we have instead is legal awareness workshops or programs educating the public on their rights when they're dealing with certain issues. So I think that is the limit of what Singaporeans are exposed to, which is why I think more can be done in this regard.
Thank you for your sharing. 其实这个我都有兴趣了解。
I'm quite interested to the situation in the mainland, how to promote the rule of law at the level of a community, grassroots community, from the perspective of each ordinary citizen, what the government should do, what the plan of the nation is taking. Talking about the community and the rule of law, I'd like to make some points. At my bachelor's school and my master program, I have been working with the legal aid programs. I think in most of the university, we have the Office for Legal Aiding, which is a self-initiated campaign. It could promote rule of law over the community. You know, how could people build the awareness of rule of law? It should have started with the knowledge of law, and that is the foundation of legal belief. China made good work in the community level. To further that, the nation could put more efforts in promoting and rule of law through making entertainment material. Then they can influence more people and make people kind of the awareness that abiding law is a kind of the good conduct.
The next question is for Jason. Just now, you shared with us an interesting concept, and that is gamified learning. So here's a question. For gamified learning, so it helps the promotion of rule of law among the young generation. For very small children, for example, the kindergarten kids and primary school students, how can we use this concept of gamified learning? What kind of games can be offered to them? Can you share some examples? Right. With gamified learning, we advocate that people should learn things in a happy atmosphere through games. For small children, for example, those in primary schools and kindergarten, this is a good way for them to come into contact with these concepts. Of course, we will not use very difficult jargons and terms. We will use layman concepts, but we can start from day-to-day examples. For example, these children know that there are different roles in society. For example, in a classroom setting, there may be students breaking rules of the school, and then they may have to face some responsibilities and so on. And there are concepts related to the rule of law concept, which are more complicated, but then these can be illustrated to them in very simple way. They will not be required to recite things. They can put themselves into certain roles. With simulation, they will do role play and they will exhibit different behavior. So what kind of consequences will they face? What are their options? So these can help them learn the concepts. So gamified learning suits young children. Thank you, Jason. Because of time, now I would like to ask you the last question.
For each of you, and I would like to know, what is your short answer when you see the question? What is the rule of law? Could each of the speakers do a very brief sharing? Let us know why. Can we start with Kelvin? Kelvin, Isina.
Kelvin, you go first. I think a short answer to what is rule of law is judicial independence. I think that is the most important concept. I think everyone needs to understand what judicial independence really is. You have to live in a certain community in order to know and understand that. Thank you, Kelvin. Angel? I will refer to equality. This is not only about equal rights, but I'm referring to consistent understanding of the whole legal system.
Senshi?
So I think rule of law is a concept that protects everyone, their fundamental rights, and also equality before the law. So in order to do that, we need to ensure independent judiciary to execute the task to ensure that their right can be protected and the nation will be peaceful. And for that to happen, all citizens also play a role, not just to promote justice, but also they should play their part by adhering to the rules and regulation, becoming a good citizen. That's all.
Thank you, Sanshin. How about Xiao Dao?
Thanks very much. To be honest, rule of law, I learned this before I got the idea about the guidance structure. To put it simply, rule of law, like I mentioned before, is in a long term of the society, all the law-abiding activity, whether it's related to execution and legislation, as long as we have the legal belief and we take the action under the legal belief, it is a part of rule of law.
I think to me, rule of law is essentially access to justice. I think as many speakers today have pointed out, you can have the most perfect legal system, but if individuals are too poor or too uneducated to access the legal system, then the legal system may not function as properly as it should to protect rights, which is essentially the purpose of the legal system.
And Jason?
So we have talked a lot about different principles of rule of law. Let me be a bit more macro. Rule of law helps Hong Kong, in particular, to have a bedrock for success. It connects different industries and people of different age. So if we can uphold rule of law, then our society can have better development with a very important foundation. Thank you, Jason. I would also like to share, when I ask my friends, when you hear rule of law, what comes to your mind? It is quite interesting that some young lawyers said the first thing that came to their mind is the Secretary for Justice and also Department of Justice. So I believe rule of law is really closely related to Department of Justice. Well, time is up. I want to thank all speakers.
Department of Justice for making this happen, and we look forward to seeing all of you in the next event. Thank you.
Thank you. Thank you. 再一次用最熱烈嘅掌聲。
Once again, a round of applause to thank our speakers and Sharon, our moderator. Now, please stay in your seats and please look towards our official photographer in the center and have a group picture. This panel discussion is really excellent. Now everyone will have better understanding of young people's thoughts. Once again, thank you, Sharon, Kelvin, Angel, Glenda, Sanchin, and Jason, and also Mr. Lai. Thank you. Thank you all. So, guests, can you please return to your seats now? Well, time flies. The 5-day Hong Kong Legal Week 2022 is coming to an end. Just now, we had the third panel session, which is a very special one because apart from listening to the young generation's views in their different roles on how to do rule of law education, they also talked about how to popularize rule of law education. We have also heard how the young generation brainstorms and discuss in order to facilitate the deepening of rule of law. Jason referred to 3E: educate, engage, and execute. Today, through this Rule of Law Congress, Rule of Law and Justice for All, well, at the beginning, the Secretary for Justice said in his opening remarks that we want to deliver a very important message. Law and rule of law is closely related to each one of us. Everyone has the responsibility to uphold rule of law in Hong Kong. This is our very important mission. So now our event is coming to an end. Let me now invite our Deputy Secretary for Justice, the government of the Hong Kong SAR of the PRC, Mr. Horace Cheung, to deliver closing remarks. Deputy Secretary, please. Secretary for Justice, distinguished guests, friends, good afternoon. Without us knowing, actually, the Rule of Law Congress is coming to an end. We have so many remarkable guests with us. We have Professor Tirado this morning as our keynote speaker. He is the Secretary General of UNIDROIT. He talks about how rule of law can facilitate sustainable development. We also have from Law Society, Mr. C.M. Chen, and also from Bar Association, Mr. To, leading the panel discussion for us. We also have a number of very important guests talking about why rule of law is the bedrock of success in Hong Kong for many different industries. So we talked about also diversified dispute resolution mechanism and future development. These are some very important topics that we have shared. Speakers today include Mr. Tan Kwok Ching from Court of Final Appeal, Mr. Yuen Kwok Keung from International Arbitration Center, and also Ms. Tan Wen Chi from the Hong Kong Palace Museum. So they talked about how we can enhance and optimize our dispute resolution mechanism. We have a very comprehensive dispute resolution mechanism, and this can serve all members of the public so that there will be affordable, effective and timely legal and dispute resolution service. This is a very important element of rule of law. Hong Kong is a leading international financial, legal and dispute resolution center. Our strength is undisputed. So we have different experts with different background and expertise. So for needy people and enterprises, quality and diversified legal and professional services are provided. We also possess a sound legal system and supporting facilities, a deep rule of law foundation. We also have the staunch support from our country, and we are closely connected to the international community. Besides, among various international law firms and international legal organizations, Hong Kong is their choice for their operations here. We have ALCO, which chose Hong Kong as a legal hub, and this year in May, they were officially opened. Renowned international legal organizations generate synergy, which can lead to more opportunities for Hong Kong. Of course, recently, there is another very good news. With the support of our motherland, the preparatory office of the International Mediation Academy will be set up in Hong Kong. This organization will offer an economical and effective mediation new platform for international disputes. So it adds to the existing international dispute resolution mechanism. In order to offer peaceful and friendly dispute resolution method and to maintain cooperation and friendly exchange within the international community, this office is really meaningful. And next year, this office will start the preparation work. Their choice of setting up the office in Hong Kong reflects that the international community is full of confidence in Hong Kong as an international legal and dispute resolution service center in Asia. Besides, we have to say that there are a number of speakers from different professional fields. They are experts in their fields. So today, we are not only talking about rule of law from legal perspective. Our guests share their insights and expertise, and so we talk about the concept from finance, maritime industry, technology and innovation field, culture and arts perspectives, so that we have an understanding of the importance of rule of law on different industries. As the Secretary said this morning, the 14th five-year plan of our state and also the Greater Bay Area Development Outline Plan and other national strategies all show the staunch support of our state, on Hong Kong. So endless momentum is being injected into Hong Kong. The 14th Five-Year Plan has confirmed the 8-center positioning of Hong Kong: legal dispute resolution, shipping, emerging industries like aviation, innovation and technology, IP, and arts and culture. What is worth paying attention to is for legal and dispute resolution service. It is closely related to our status in those 8-center role. So there is very important supporting effect. Hong Kong is a leading international financial center because we have a sound legal and regulatory system that underpins our development. And in shipping, commerce, aviation, technology and innovation, and all other fields, different types of contract positioning will be involved. And we need effective guarantee of our rights. And whenever there are disputes, various parties need effective and fair way of resolving the disputes. In terms of IP, trading, art and culture, creative industries development here in Hong Kong, we also rely on our IP protection system, which is consistent with the international standard, and we have also comprehensive dispute resolution mechanism. Another point is that we have common law system according to the basic law, and we are the only jurisdiction practicing common law in China. The common law system can keep up with time and can meet the needs and serve the community, the business and investment community of both Hong Kong and the international scene. Hong Kong has a very long common law tradition. Our common law system is open, transparent, practical, and independent. There is very sound case law as well, which is reputable in the world. So Hong Kong is able to give full play to our strengths as a connector between China and the world. Besides, another highlight of this Rule of Law Congress is the last panel discussion on the important role of young people in promoting rule of law. That panel discussion, as seen just now, is moderated by a young legal professional, and our speakers include a new solicitor, new barrister, award winner of International Legal Exchange, young scholar, and also student representative from a renowned university.
They have taken us on this journey from their perspective and examine how youngsters can make contribution to the legal system, jump out of the box, and then promote legal education. For example, we have heard that we can rely on innovative technologies, games, simulation, so that we can promote the idea of rule of law in a relaxed and playful way. Another example, legal students should have their own project and complete at least 25 hours of pro bono work before they can graduate. Such experience sharing is truly valuable. It really drives us to think about how we can further promote the work in relation to rule of law. I've chosen to deliver my closing remarks in Cantonese because I want to send this message to the society. The rule of law is not just for scholars or the legal sector. It matters to every single person in the society. It matters to our next generation. When there are more people in the society who have the right idea about rule of law, we can solidify this foundation further. Making rule of law education a common topic is our work in the next few years. The CE has already announced in his recent policy address. Under his leadership, we are going to set up a steering committee that focuses on the education of rule of law so that we can work with different sectors to promote the right messages in our society so that we can be flexible and effective in engaging the public so that they understand the concept better. Finally, I would like to thank your participation and your support. Thank you all the working staff and our colleagues for your unreserved efforts, creating great results to this Congress. Thank you.
多謝副司。
Thank you. Thank you. Please return to your seat. Dear guests, that concludes our final session of the Congress and also concludes the legal week this year. Thank you so much for your participation this year.
Rule of Law Congress, Rule of Law and Justice for All has come to an end, and this also marks the last event of the Hong Kong Legal Week 2022. On behalf of the Department of Justice of the Hong Kong SAR of the People's Republic of China, we would like to thank all our excellent speakers and moderators for your wonderful exchange and discussions, and to all our participants here and also those watching the online broadcast. Thank you for attending the Congress and for making this a great success. We would also like to take this opportunity to express our sincere gratitude to our supporting organizations. They are the Asian Academy of International Law, the Hong Kong Bar Association, Law Asia, the Law Society of Hong Kong, Invest Hong Kong, Hong Kong International Arbitration Center, Hong Kong Mediation Accreditation Association Limited, eBram International Online Dispute Resolution Center, Hong Kong Maritime and Port Board, and the Private Wealth Management Association. 大家離開之前啦。
Before you leave, allow me to remind you, if you have obtained the SI headset, please don't forget to return it. And your views are very valuable to us, so please do approach the QR code next to the exits, fill out the survey, and return them to us.
Remember to return your SI headsets at the entrance and also complete the evaluation form by scanning the QR code right at the entrance. For online participants, please fill out the online evaluation form. Last but not least, once again, thank you so much for joining us at the Hong Kong Legal Week 2022, and we hope to see you all again next year. Thank you.